You're waiting for the green signal from the students, is it?
Yes, ma'am, we are starting.
Yeah, so you can ask everyone to switch off, and if they're using two devices to have only one.
A very good afternoon and a warm welcome to all the dignitaries, the moderators, and the audience members that we have present today. Welcome to the virtual discussion cum public consultation on transformation of the criminal justice system in India, initiative by the Ministry of Home Affairs, Government of India, and conducted by Symbiosis Law School, Pune, Symbiosis International Deemed University. The Government of India aims to make fundamental changes to the Indian criminal law framework and the criminal justice system in order to make it more accessible, affordable, and citizen-centric. The Ministry of Home Affairs, Government of India, has therefore invited Symbiosis Law School, Pune, to engage in an active discourse that reviews the criminal laws of the country and brings forth the necessary recommendations by engaging the public to improve them. In furtherance of the same, on the guidance of Dr. S.B. Mujumdar, Chancellor of Symbiosis International Deemed University, the team of SLS Pune, headed by Director and Dean Dr. Shashikala Gurpur, have reviewed the literature and collected data from more than 120 stakeholders, including High Court judges, lawyers, NGOs, scholars, litigants, youth, etc., for understanding the gaps in the criminal justice system to make the system more citizen-centric and efficient. The SLS Pune team that has worked on this project consists of Dr. Atmaram Shelke, Senior Assistant Professor, Ms. Aditi Mane, Research Fellow, Dr. Ashish Deshpande, Assistant Professor, Ms. Chetrali Deshmukh, Journalist and Visiting Faculty, and Professor Shirish Kulkarni, Assistant Professor, supported by other members of the Symbiosis Law School Pune team. The participants of this event will include over 17 experts and stakeholders from National Legal Services Authority, retired High Court judges, former police officers, including anti-terrorist squad, eminent lawyers, criminologists, legal academicians from across India, researchers, media personnel, cyber forensic experts, psychiatrists, sociologists, and others. The discussion will be moderated by Director and Dean, Dr. Shashikala Gurpur, a former member of Law Commission of India. Based on suggestions received from the above eminent personalities and an online public polling, which will be conducted at the end of each panel, a consolidated list of recommendations will then be submitted to the Ministry of Home Affairs, New Delhi, on behalf of Symbiosis Law School, Pune. To deliver the welcome address and introduce the theme of today's consultation, I would like to invite Dr. Shashikala Gurpur, Director, Symbiosis Law School, Pune, Dean, Symbiosis International Deemed University. She is the recipient of several distinct honors, awards, and recognitions for her contributions in legal education, gender sensitization, and community outreach programs. In recognition of her contributions to the Indian Legal Academia, she was listed in the book 100 Legal Luminaries of India by LexisNexis, and has also been conferred with the prestigious annual Kittur Rani Chennamma Award by the Government of Karnataka in 2018 for her work towards the empowerment of women. Welcome, ma'am.
Thank you. Good afternoon, our esteemed panelists, including the most distinguished members like Justice Madam Shalini Fansalkar, Advocate Withdrawal Nikam, the famous public prosecutor, our very senior lawyer, Mr. S.K. Jain, and we are expecting many more, our very esteemed police officer, Mr. Banu Pratap Barge, our very distinguished academic colleagues, journalists, advocates, psychiatrists, forensic experts, faculty, and students. A very warm welcome to each and every one of you. I'm very happy to welcome each and every one of you to this very, very special occasion, which is very close to our heart. Our earlier historical engagement with such public consultation has been way back in 2011, the last I can remember. After I came here in 2007, by 2010, when I had the opportunity at the Law Commission, we took the initiative of bringing together hundreds of judges from across Maharashtra and all the members of the Law Commission of India to deliberate on how to improve the justice delivery system. Prior to that, before I took over, a year prior to that, we had distinguished and now late advocate Ram Jethmalani, as well as our esteemed legal legend Dr. Madhav Menon, taking the lead to look at criminal justice system reforms in the light of Malimat Committee report. So this college hasn't done this venture for the first time. True to the public spirited origins of Symbiosis through our founder, Dr. S.B. Mazumdar sir, to alleviate the plight of international students in Pune way back in 1970s. And then our various engagement as a law school in terms of extending legal education to public through our community legal service, and a number of accolades and consistent top 5 position in the All India ranking through all-round excellence that we represent. We thought that when the Home Ministry wrote to us, it's only to engage rather than postpone the idea. So in January, we received this note from none other than Home Minister, Mr. Amit Shah. We wrote back saying, yes, we will engage in your desire to make the criminal justice system more people-friendly, more people-centric, expedient, quick, and look at some of the flaws in the justice system, and most of all, most participatory, where public engage or people engage in the legal system. I would not like to preempt the eminent speakers who are going to deck the panelist chair here or gallery here, but we thought that our tradition in Symbiosis Law School, which has been a prize-winning tradition of proposing community-based law reforms. Now, this very idea of community-based law reforms hasn't been a very old methodology of looking at law reforms. It is the reform approach which has come in the 90s by National Law School Bangalore and Asian Development Society, where I had the opportunity of guiding a team. And we became the national award-winning team among many others. That tradition again got discontinued. And in Symbiosis Law School, Pune, on Gram Panchayat reforms, especially in terms of ladies' participation, on community land allotment by the government, the Gauran land, and also on the issue of natural resources, we have had prize-winning community-based law reform proposals. Recently, we did on uniform civil code proposal, especially on adoption and surrogacy. So there also we won the national award. So we have had as a law school this tendency to go to the community, seek community opinion, and then what we call as learn, unlearn, and relearn approach. This way we prepare thousands of students. We have about 2,000 students in our law school, motivated to take on the future by not leaving law reform work to the legislature alone, because a house of 500 plus deliberating on such a vast nation would be much more meaningful and participatory if youth participate in that, if everybody participates, and it will bring law closer to the people also, and it will make, as Home Minister desired, justice system to be more engaged with the people. So when the letter came in January, we sent a consent, but then with the COVID, it all got postponed, our initiative. In the meanwhile, National Law School Delhi also, I'm going to present those details in my presentation. Next slide, please. I'm very happy to introduce to you our, which has Dr. Atmaram Shelke, who is a senior assistant professor, who is a very deep researcher as far as criminal justice system is concerned. Ms. Aditi Mane, who is a junior research fellow. Mr. Ashish Deshpande, he's Dr. Ashish Deshpande. Ms. Chaitrali Deshmukh, who is a journalist and visiting faculty and pursuing PhD with us. Professor Shirish Kulkarni, Ms. Apurva Singh, our JRF, and Ms. Aishwarya Mane, our JRF. These are the primary contributors, and in supporting and assistance at the technical level and in rolling out today's program, we have had the support of our Professor Rupal, our assistant professor Virendra, Ms. Priyanka Mazumdar, the assistant professor, and our advocate Sangramjit Chavan, who is also a visiting faculty and a part-time teacher here, and our ICT team of Mr. Jatale and Mr. Balesh Zorwekar. Now, if we look at how we identified key areas. That is the question, because in 3 hours, how a vast ocean of 3 legislations, actually 4, which our Home Ministry wanted us to reflect upon, namely the Indian Penal Code, Criminal Procedure Code, Indian Evidence Act, and Narcotic Drugs and Psychotropic Substances Act. It's a very tall order for a 3-hour deliberation. So we truncated this by months and hours of work, hundreds of hours of work by this team at different levels. So we created the original questionnaire, which took about a month to run the pilot with someone and then improve it. And then we looked at after the questionnaire was sent out and brought back, the numbers were very less. Some of the stakeholders in the criminal justice system were not, for example, police officers were so busy with the COVID, they could not respond. Then someone like Bhanu Pratap Bargeswar came to our rescue, and some of the officials who are in the top ranks also helped us. And so most of our colleagues have been through the practice line. I myself have fought cases of women and things like that. So we have had such guidance. And in developing such questionnaire, we had to look at, some of the phenomena of this country. Because parallelly, 3 developments were happening. Home Ministry was writing to many law schools. So Gujarat Law School was doing a little bit. Our Mumbai National Law School was doing a little bit. And Delhi National Law School had created a committee to directly interact with the Home Ministry because of the convenience of proximity. So we studied their websites as well. However, when we identified our themes, we did not want to duplicate the work, because we wanted to focus more on what is so unique to the location where we are. If we say it is Western India, then we have to concentrate more on Maharashtra because of what we call as convenience sampling and because of the locational advantage. So what we took as the basis was, please move the slide, National Crime Records Bureau. It published a report in 2019 under the aegis of the Home Ministry, which was published in newspapers in bits and pieces sometime in November 2019. And it was only 2 months after that we had received the minister's letter. So we saw that highest reported crimes in India in 2019 were more about property related. They were 4% on property related and 22% in terms of tangible property, and miscellaneous about 23%, liquor and narcotics related 24%, but offenses against human body was 27%. I was not going to take it on this kind of a statistical broad percentages. So we investigated deep, and we found out that among the crimes against women rated the most. I mean, they were the highest in terms of bodily offenses, and we are still reeling under the shadow of Hathras and all these kinds of atrocities against women with multiple disadvantages. So we saw that when it came to these highest number of crimes, which are crimes against women, and which states were leading, I always had this very great picture about Maharashtra, but I was shocked to see that states like Odisha, states like Maharashtra having a very high number, and within those also 2 categories of crimes being on the top level. One is cruelty by husband or relative. So again, marriage has become the focal point here, family and all that. And secondly, assault on women with the intent to outrage her modesty. So the bodily dimension very much sits with the disadvantaged status and a female or the other gender kind of body. So this was one point which was intriguing for us. Second, next slide, please. We also saw that if you look at disadvantaged section like SC/ST, we saw simple hurt being a very top kind of crime, and then there were other crimes also against them, and offenses against SC/ST women in terms of rape and outraging modesty was quite a big number. So that's an interesting slice in terms of reality of India's criminal justice system's pain areas. Let's go to the next slide, please. Even the state-wise ranking is quite interesting. We see that 44% comes in the green zone, and that green zone is other crimes, and the blue zone of 30% is simple hurt, and the orange zone of rape in the pie chart is about 8%. And here again, certain states seem to be recurring in terms of number of crimes. So let's go to the next slide, please. So I'm just setting the context. So this is again reflecting the crimes against the ST, where again the blue zone corresponds with a certain state, and here we are speaking of state of Madhya Pradesh. Of course, the population is also highest there of the ST. Then offenses against property reflects in the state statistics. I mean, these are just glimpses, but when we are doing an analytical study where our reforms should be targeting, in terms of offenses against human body, you have Bihar leading the lot, and then we have regionally Uttar Pradesh also being there. So in terms of offenses against human body, we have hurt, we have kidnapping, we have assault, we have rape, and particularly assault against women, and then murder and other crimes. Let's go to the next slide, please. Ministry of Home Affairs wanted us to focus more on safety and security of the individual, the community, and the nation. So it begins with individual. And is every individual the same? I was reading about vulnerability. It was telling that we can't be universal when we look at it. We have to be particular also. Particular was the one which we revealed in the earlier pie charts. Report. Particular situation of women, particular situation of SC, ST. Now, prioritizing the constitutional value of justice, dignity, and the inherent worth of the individual. If you ask me, safety and security we looked at in terms of special types of themes that we have addressed, where we are looking at conviction rates to be improved, providing witness protection, providing victim protection, and also in terms of looking at the issues within the prison system, and how the prosecution can be withdrawn and that whole process can be misused, how technology is going to be utilized in terms of creating a safe and secure India. And then we have constitutional values coming in terms of, once again, within the prison system we have dealt with because of the prosecution being in the focus in the beginning. So we there looked at in terms of how denial of bail could be looked at in terms of being very narrowly cast, because now it is not so rationally done in terms of the reality of overcrowding of prisons, and protection of the liberty and dignity by distinguishing, the classification dimension. So making the system more citizen-centric means how do you look at the vulnerable? Speedy and affordable justice. How is the Legal Aid Services Authority acting? So we also invite the esteemed audience and panelist attention to National Law School Delhi's website, where they have put a highly technical kind of provisions based recommendations on the three legislations. They have not touched upon the NDPS. That is where we differ. Secondly, they had a deliberation schedule, but we did not see a deliberation report. We wanted to keep the deliberation more participatory as the ministry wanted, bringing all stakeholders here and bringing feedback and engaging audience in polling. Then we also saw in the National Law School Delhi approach more emphasis on IPC and less emphasis on Criminal Procedure Code and NDPS and Evidence Act, less emphasis on long-term structural reforms such as political interference, quality and role of police and prosecutors, speedy trials. There was less emphasis on prison reforms as well. Whereas our dimension of transformation of the criminal justice system is based on the literature that we reviewed, and we picked these few themes, and we collected data from over 100 stakeholders and their practices, and aligning it with ministry objective. And equally, we emphasized the structural changes and the legal changes. We believe that if you're talking about justice system, previous slide please, we don't want to just concentrate on the legalese, on the technical side of interpretation of the law. We believe that there needs to be better piecing together, integration of the different pieces of criminal justice system working together, and technicalities of the law to be seen in that light to be more effective. Otherwise, low conviction rate cannot be tackled. And then looking at victim protection and rehabilitation, resolving issues with current prison system, misuse of withdrawal from prosecution, and forensic cyber crimes and forensic cyber law and NDPS Act. So we have been very focused on these things, not to sound repetitive and not to ignore the most crucial issues. Next slide, please, quickly. So we also have come across just on Saturday a book published from our Bombay colleagues in National Law School Bombay. So I'm bringing Delhi National Law School's work. National Law School Bombay's Vice Chancellor Dr. Uke and his team have edited this book where they have many points, but most of them seem very academic. But we picked these points which are very, very interesting. One is on digital autopsy to avoid invasive autopsy in postmortem, then wrongful conviction, bail, where narrowing down of the bail conditions to be given, and a Law Commission report of 2017 to be focused. Their book has focused more on the juvenile justice, on the POCSO, modesty of women, police behavior, police and prosecution, and over-criminalization of the transgenders. However, we submit humbly before you, the panelists and the audience who are going to be polling, that SLS Pune approach is different because of the multi-level data from the stakeholders that we have collected, the diverse stakeholders we have engaged. Therefore, our tentative recommendations have been drawn up on the basis of these data, which we will authenticate, thrash out, discuss, and finalize in today's consultation cum public discussion. So as I welcome all of you, I'm very happy to present before you where we come from and why we are distinct, how this is a unique differentiator. Next slide, please. So this is the next part that is going to follow, and I'm going to hand it over to the compeer. Thank you one and all for your kind attention, and welcome once again.
Thank you, ma'am, for your welcome address and setting the stage, emphasizing on the gravity of the theme for today's public consultation and the need for an active public discourse in these matters. To introduce our esteemed dignitaries and experts today, I would like to invite Dr. Bindu Ronald, Deputy Director, Symbiosis Law School, Pune.
Thank you very much, Lasya. In this virtual discussion cum panel consultation on transformation of the criminal justice system in India, we have a galaxy of star-studded panel of experts, and I have the privilege of introducing our panelists for this discussion cum panel consultation. To begin with, we have Justice Dr. Shalini Phansalkar Joshi, Bombay High Court. Dr. Phansalkar possesses the distinction of being the first lady advocate and the first lady judge from Karad. Ma'am joined the judiciary in 1988 in the cadre of Civil Judge Junior Division and Judicial Magistrate First Class and worked at Pune, Nanded and Thane. Thereafter, Ma'am was promoted to the post of Additional District Judge in June 1997, and she also worked at the Special Tada Court and the Special Court for Offences of Atrocities Against Women at Pune, Nashik and Ahmednagar. Ma'am was then the Joint Director of the Maharashtra Judicial Academy from 2009 for 4 years and trained more than 450 judicial officers. Ma'am was further appointed as the Principal Judge, City Civil and Sessions Court, Greater Bombay, until her elevation to the Bombay High Court on 21st April 2014 as the Registrar General of the High Court. Ma'am was elevated as an additional judge of the Bombay High Court on 1st January 2015 and permanent judge on 17th November 2016. Few of the very well-known and landmark cases presided over by Ma'am are the Kotewari gang rape case, the Spanish lady rape case known for recording the evidence of the victim through video conferencing from German consulate at Berlin, the Shakti Mills rape case, the first to deal with the newly amended section 365E of the IPC. Thank you, ma'am, for being with us today. We have with us Dr. Advocate S.K. Jain. Advocate S.K. Jain is a practicing advocate since 1972, starting his law firm in Pune with approximately 20 advocates and 3 trainee advocates Today, his law firm has 300 advocates with him as colleagues and trainees. He has been the president of the Niramay Trust, Pune, that works for the upliftment of slum-dwelling children, especially girls. So far, more than 1 lakh children have been given vaccination by the trust. He has also been a director of the Century Enka Limited, Century Textiles and Industries Limited. He is the chairman, Constitution Committee of the Jain International Trade Organization and patron member of Science and Technology Park of Savitribai Phule, Pune University. He was the honorary president of Kharki Education Society since 1979 to 2016, where he improved and strengthened the financial position of the trust. He's the president of the Pune Adhivakta Parishad, chairman of the advisory committee of Apang Kalyankari Sanstha, Vanavri Pune, and has represented various government bodies, local authorities such as Pune Cantonment Board, Kharki Cantonment Board, Dehu Road Cantonment Board, NDA as Special Counsel for Pune Municipal Corporation, and various social organizations in the District Court of Pune. We have next with us Advocate Withdrawal Nikam, Special Public Prosecutor. Advocate Withdrawal Nikam is famous for having worked on prominent murder and terrorism cases. In his entire tenure, Sir has secured 628 life imprisonments and 37 death penalties. Sir has worked on cases such as the Gulshan Kumar murder case and has secured life imprisonment for the convict. Sir has also worked on the Khailalji massacre and others, and had secured death penalties for 6 convicts and life imprisonment for 2 others. Sir is also known for working on the Shakti Mills gang rape case and has secured the death penalty for 3 repeat offenders, and the Mumbai acid attack case where he secured the death penalty for the convict. Sir is famous for working on 2 famous trials in 1993, the Bombay Blast, and the Ajmal Kasab trial. Sir has secured the punishment for life imprisonment for Abu Salem in 1993, and for his role in the 26 attacks. In 2010, Sir has represented the Indian government at a worldwide convention on terrorism held at United States in New York. In the year 2016, Sir was awarded the Padma Shri by the Government of India. Next, we have Dr. Shashikala Gurpur, Director, Symbiosis Law School, Pune, and the Dean of the Law Faculty at Symbiosis International University. Ma'am is a member of the Board of Management of Symbiosis International University. She was the former member of the Law Commission of India. She's currently a member of the Academic Council of National Judicial Academy, Bhopal. She's on the academic boards of various national law schools and universities. She's also a member of the Curriculum Development Committee of the Bar Council of India, and she was awarded the Fulbright Fellowship in 2011. Ma'am received the National Merit Scholarship for top score in SSC and National Hindi Scholarship for the top score in Hindi. And in 1992, she received the Karnataka State Youth Award for Excellence. In 2004, she got the AHRP grant to pursue postdoctoral at Edinburgh University. In 2014, she was conferred with the My Conscience for Equality Award by the Global Ethics Forum, Geneva. She is listed amongst 100 legal luminaries of India in a book published by LexisNexis. Recently, Ma'am also has received the prestigious Kittur Rani Chennamma Award by the Government of Karnataka. We next have Mr. Sunil Chauhan, Director, National Legal Authorities. Mr. Sunil Chauhan is currently the Director of the National Legal Services Authority. Sir has worked as civil judge and judicial magistrate and was also the secretary, Panchkula District Legal Services Authority. Sir was the joint member secretary, Haryana State Legal Services Authority. He was the joint member secretary, Haryana State Legal Services Authority, as well as a project officer, National Legal Services Authority, New Delhi. He has drafted the Legal Services Camp module, Legal Services campaign titled Connecting to Serve, the front office guidelines, the protocol ensuring access to justice for widows living in shelter homes, and he is also responsible for holding a lot of campaigns that enhance the achievement of broad vision of access to justice. On our panel today, we have Shri Alok Agarwal, Research and Policy Advisor, NALSA. Sir joined Delhi Judicial Service in November 1992. He was posted as the City Judge Metropolitan Magistrate, Secretary, District Legal Services Authority. He was promoted to the Higher Judicial Service in January 2006. Later, he was posted as the Labour Court Additional District Judge. Further, Sir has served as the Special Judge for CBI. From December 2010 to July 2012, he was the Additional Director and Director, Delhi Judicial Academy. Further, he served as the Member Secretary, NALSA, from February 2015 to May 2020. Dr. S.C. Raina, he is also there and on our panel today. Sir is the Director, KIIT. Raina sir is currently the Director of KIIT School of Law. He was the founding Chancellor, Vice Chancellor at the National Law School, Simla, and former Dean of Faculty of Law, Delhi University. Professor Raina has a teaching experience of more than 35 years, and he was the expert of the 9th edition lecture series on criminal law organized by United World School of Law, Gandhinagar. He has been remarkably involved in the journey of academia and has inspired hundreds of students with his dedication towards law and unbounding legal knowledge. Some of his areas of interest include criminal law, criminal justice administration, and research methods. Sir is also a distinguished faculty at Symbiosis Law School, Pune. We have with us Mr. Hitesh Jain. Advocate Hitesh Jain's practice encompasses 24 years of experience in all branches of litigation: civil, criminal, commercial, and constitutional matters. He has represented clients in the Supreme Court of India, various high courts in India, district courts, consumer forums, competition commission, arbitration proceedings, etc. He has acted as a special counsel for the state of Maharashtra in Bombay High Court and the Supreme Court of India. His areas of specialization involve a large range of subjects from corporate law, media law and sports law, arbitration and dispute resolution, banking and finance, civil and general litigation, competition law, consumer disputes, corporate laws, intellectual property, labor and human resources disputes, media and entertainment laws, real estate, and land laws. Advocate Hitesh Jain has advised several leading media and Bollywood personalities in their legal encounters. We next have Advocate Satish Manishinde, who is a well-known criminal lawyer in India dealing with high-profile cases involving top-notch industries and eminent personalities. He started his career way back in 1983 with an internship at the office of the celebrated lawyer, late Advocate Ram Jethmalani. He served as an associate at his office for 10 years and meanwhile took up civil and criminal cases. He represented popular actor Sanjay Dutt in 1993 and Salman Khan in the Black Buck poaching case. Along with these cases, he also managed cases like the Mumbai police inspector Dayanayak's disproportionate assets case, Bookie Shohab Mehta's match fixing case, and Rakhi Sawant's abetment of suicide case. He's one of India's top-notch criminal lawyers, advocate, and entrepreneur who has achieved success in his career through dedication towards the field of law. We have with us Dr. Harish Shetty. Dr. Harish Shetty is a practicing psychiatrist, and he has obtained a rich experience in various areas of mental health work. This is evident from his appointment as a consultant at the Seva Sadan De-Addiction Center and the National Addiction Research Center in 1989. His petition with the Maharashtra Human Rights Commission to abolish the segregation practiced in schools, that is separating children by virtual marks and dumping those who scored less in a separate division in schools, was accepted, and the segregation was abolished. As a psychiatrist, Sir has been a member of the committees appointed by the Bombay High Court overseeing the work of MDC centers that houses mentally retarded children. He has been a star witness in the infamous Panvel and Thane orphanages cases of child sexual abuse, where the convictions were granted to the offenders. He has assisted the Bombay High Court on various mental health issues. Dr. Harold DeCosta, our next panelist, and he is the president of the Cybersecurity Corporation and CEO of Intelligent Quotient Security System. He is one of the senior consultants for the law enforcement agencies on matters relating to cybersecurity breaches and cybercrime investigation. He was a part of the Global Cybersecurity Summit, a regular writer in leading newspapers, and an expert in cybersecurities in various TV channels. He had the distinction to train Bangladeshi, Sri Lankan, and Burma Supreme Court, High Court, and District Court judges on cyber law, cyber forensics, and digital evidence organized by National Judicial Academy, Bhopal. Further, he has worked on various cyber cases relating to large government enterprise, Bollywood multinational companies, banks, telecom, education, media, gas subsidies, etc. He has real-time experience in capturing digital evidences relating to various cybercrime cases, relating to banking frauds, data theft, software piracy, cyber defamation, social media cyber, intellectual property rights, cyber terrorism, etc. He has worked for more than 4,500 cases of cybercrime from 7 countries and trained more than 35,000 cops and about 4,000 judicial officers in various facets of cyber forensics, cyber law, digital evidence, and cybercrime investigation. I have the privilege now to introduce Mr. Bhanupratap Barge, Retired Assistant Commissioner of Police, Crime Branch, Pune City. Mr. Barge joined the Maharashtra Police in 1985. Since 2005, he is posted in Pune. He is associated with many social organizations for better police public relations and anti-terrorist, anti-national activities. Some of his special awards are the President's Police Medal for Meritorious Service, DG's Insignia Award by DGP Maharashtra. He was the first Indian police who received the Survivors Club membership, an international award for action against terrorists. Till date, he has received more than 430 awards. He believes in doing anything with a keen interest and from the bottom of the heart and serving people as much as possible. We have with us, I'm sorry, I think I mentioned Sir's designation wrongly. He is the Assistant Commissioner of Police. We next have Advocate Sampath Bulusu, General Manager and Head, Legal and Corporate Affairs at Shell Hazira, LNG and Port Companies. He's an alumnus of Symbiosis Law School, Pune. He has worked as an advocate in the High Court of Andhra Pradesh. He has worked as an assistant manager legal at Larsen & Toubro. Advocate Bulusu has also been a part of the Gujarat Gas Company Limited and has also worked with Schlumberger and Transocean. Further, he has been associated with Symbiosis Law School, Pune as a guest faculty since 2008. We have with us Dr. D.P. Singh, Associate Professor under the School of Research Methodology, TIS. Professor D.P. Singh is presently working as an Associate Professor under the School of Research Methodology in Tata Institute of Social Sciences, Mumbai campus. His area of interest is qualitative research, political sociology, and education. He teaches research methodology, social theory and research, and qualitative research to integrated and direct PhD students, and has been associated with TIS for almost 35 years now. We have with us Mr. Nitin Kondavle Patil, an IRS. He's presently working as a Joint Commissioner of Income Tax, Mumbai. He was a gold medalist in Masters in Computer Science. He achieved 3rd rank in Maharashtra Public Service Commission and was selected for Indian Revenue Service Commission in Union Public Service Commission. His expertise is in transfer pricing and international taxation. He's a member and advisor to many committees of Government of India and has played a key role in the pilot project of recently launched Faceless Assessment Scheme of the Revenue Department. We next have Dr. Arvind Tiwari, Dean, School of Law, Rights and Constitutional Governance, TIS. Sir is the Dean of the School of Law, Rights and Constitutional Governance, and he worked as a senior researcher with the National Human Rights Commission, New Delhi, in August 1995. Later, he also served as Dean, Office of Student Affairs at TIS. He has played a significant role in imparting human rights education to the various stakeholders, including criminal justice functionaries, such as police, prosecutors, judiciary, and prison officers through various training and capacity building programs. He has been extending professional services to several universities and other constitutional bodies of the central and state governments, etc. And more recently, he was elected as the President, Indian Society of Criminology, and Vice President of the Indian Society of Victimology. We also have today with us Advocate Latika Salgaonkar, legal academician and advocate. Advocate Latika Salgaonkar is a prominent lawyer in the Bombay High Court. She's a well-known social activist, and she has been very actively working with a Pune-based NGO, Nari Samta Manch. She has been very actively working for the cause of women and in issues relating to sexual harassment. She's also a visiting faculty at Symbiosis Law School, Pune, and she's also involved in various social initiatives taken by the college. Mr. Rohit Athavle, journalist, Maharashtra Times. Mr. Rohit Athavle is a well-known journalist and has been working as a correspondent cum copy editor in Maharashtra Times, Times of India Group. After completing his bachelor's in journalism and print engineering, he has further completed his master's in defense and strategic studies from Pune University. He has worked as a crime reporter for more than 10 years, and he has also been appointed as special SHO, assuming the role of police inspector. Besides law and order duties, he also supervises administration work of the police station. Thank you very much, all the panelists who are with us, and we look forward to hearing all of you. Over to you, Lasya.
Thank you, ma'am, for introducing our esteemed panelists. Without further ado, we'll begin with the panel discussions today. We have 7 panels of 30 minutes each. The questions for public polling will be displayed in the course of the panel discussion. However, the polling link for the relevant questions will be activated at the end of the panel discussion, and the audience members are requested to register their opinions using the links provided in the chat box at the end of the panel discussion. The theme for our first panel today is improving the conviction rates by coordination between police officials and public prosecutors. To moderate this panel, we have with us today Dr. Shashikala Gurpur as the chief moderator and Dr. Atmaram Shelke as the co-moderator. I would now like to invite the moderators to commence the first panel discussion.
Thank you, Ms. Lasya. Thank you, Dr. Bindu, for reading out the biodatas of our esteemed panelists. So in the first panel, as it was told, it is on the conviction rate improvement by better coordination between police officials and public prosecutors. I have the privilege of inviting Dr. Atmaram Shelke to present the important findings from our survey and community-based empirical data. And we have our, I welcome our very, very esteemed panelists, Advocate Withdrawal Nikam sir, Advocate S.K. Jain, Advocate Hitesh Jain, I hope he has reported by now, Mr. Bhanu Pratap Burge, and Mr. Rohit Atavale. Before we invite the panelists to speak, we want to provide them some background, although they have also already given their responses to the questions or lengthy questionnaire. It would be set better in the light of the quick overview of the data that we have gathered in and rearranged in terms of consolidating tentative recommendations. So I invite my co-moderator, Dr. Atmaram Shelke, to come and give a brief presentation.
Thank you, ma'am. Good evening to all. Next slide, ma'am. So we have collected data from the 107 stakeholders. And the first theme was about improving the conviction rate by increasing coordination between police officials and prosecutors. Next slide. Now, these are our recommendations, and these recommendations are based on partially from the data collected from the stakeholder and partially on the literature review. So first suggestion is need to change the criteria for the appointment of the prosecutor, which is part of section 24, 25 and 25 capital A of the Criminal Procedure Code. Now this suggestion has been supported by 95% of the stakeholder from whom we have collected the data. And they have stated other problems also, that there is lack of quality of prosecution. Maximum prosecutors are not talented as private lawyer. There is political interference also. There is lack of accountability, and it is leading to low conviction rate ultimately. And a few people have suggested that there shall be competitive examination and skills shall be tested as part of the competitive examination. And therefore, sub recommendation, that is 1.1, is to have a review of the prosecution's work, maybe after 1 year or 2 years. And for that purpose, independent bodies required to review the work. And suggestions from the judges and justice of the High Court shall be taken. So for that purpose, we have models like France model, German model, wherein there is independency of the prosecution, well laid down criteria, including skills are considered. And in India itself, we have Madhya Pradesh model, wherein review of the working of the prosecutor is happening. I request moderator to continue the discussion. Thank you.
Thank you, Dr. Shelke. Now I request our esteemed panelist, Mr. Withdrawal Nikam, the celebrated public prosecutor, special public prosecutor, to come in and give his views as well as suggestions, sir. Over to you, sir.
Thank you, madam, very much. Madam, let me tell you firstly that the role of the public prosecutor in the administration of justice is very important. But at the same time, he should not be a persecutor. And I have come across only two provisions in the law, wherein the public prosecutor has given an abundant discretion so far as law 21 of CRPC as well as 308 of CRPC. Now, these two absolute powers given to the public prosecutor clearly shows that a public prosecutor must act fairly, frankly, and without any hindrances. But my experience while conducting many cases, that there is some lack of coordination between the investigating agency and the public prosecutor. The moot question is why it so happened. One of the reasons which I can find that unlike in states, in US, the public prosecutor helps the investigating agency while investigating the crime. That is not happening in India. The investigating agency, that is the police machinery, and most of the times are without the proper legal consultation. They do their homework, they investigate the matter, and most of the times, once the crime is detected, once the criminal is apprehended, they remains happy. The senior cops never pay attention to the investigating material, investigation, as well as the writing material. And that is one of the reasons why there is a poor conviction rate. The other thing which I find, so far as the sexual assaults on women are concerned, see, I had the privilege to appear before Her Lordship, his Shalinji Sarkar, in Shaktiville gang rape case. Now, after the Nirbhaya's case, there is one amendment that after the attack or after the atrocity on a girl or woman, her statement is required to be recorded before the magistrate. Why? See, I don't understand, because earlier the victim has given the FIR and then she directly come to the court and she gives the evidence. But in between, if she has to give a statement before the magistrate, my experience that before the magistrate, most of the times she fumbles, she doesn't never disclose the whole story, and that will be an advantage to the other side, to the defense. I think government should read taking the statement before the magistrate, and thirdly, her evidence in the court. So I think there should be some shortcut that unnecessarily she should not be incident again and again. There will be mental trauma, and there are the omission, contradiction, appeals in the evidence, and it gives an advantage to the defense.
Thank you, Nikam sir. In the light of Nikam sir's deliberations, whether any other panel member would like to give an opinion, we have time for one or two interventions from this panel. We have the other panelists like Advocate S.K. Jain and Mr. Bhanuprataap Barge and Mr. Rohit Atavale. Would you like to come in for a few minutes and speak, please? Advocate S.K. Jain, sir. Sir, just by way of stimulating the discussion, I would like to highlight what Nikam sir told, how we need to support. Probably it brings out the need, which was there when I was practicing. It's more about supporting the survivor, the lady to speak out in the court, for example, the one who has been mentally traumatized by the experience that she has gone through. Even though there is in-camera proceeding, there needs to be a lot of out-of-court work which needs to be done to be stronger in evidence and to support the prosecution.
Madam, if I may intervene.
Hitesh, you are here. Oh, welcome.
Yes,
so please, yes.
So while seconding the observations made by Mr. Nikam, one of the solutions that was envisaged to such issues, where there should be a structured mechanism for a dialogue between an investigation and a prosecution. There should be a review mechanism where you can assess and review the performance of the prosecutors and the investigators. There was a Justice Malimat committee had come up with a report in the year 2003. And in that report, Justice Malimat committee had made a recommendation that there must be a director of prosecution that should be established in every state, whose sole job will be to, what Mr. Nikam was suggesting regarding structuring, having a structured dialogue, ensuring a review mechanism, and ensuring a difference between the investigation and the law and order wing. So this is one suggestion which was taken up by the government in 2016 also, and the government was very serious about implementing this suggestion regarding about director of prosecution, and such suggestion was made. So I think this is one suggestion one must consider, because that is where you can see the structured mechanism coming in. My second point, what I want to make is to use the technology also. Because
sorry, Mr. Hitesh. Sorry, Mr. Hitesh.
I cannot help
in
it.
every
I have
state.
an important session. I have a class. Too bad, even I. This is important for me.
Can someone please?
Ms. Nandita Sharma, could you put your mic off, please?
मुझे वो लैपटॉप in between, ठीक है, और मेरा फोन कहीं और चार्ज हो जाता है, but मैं सुन नहीं सकती हूँ.
Ms. Nandita Sharma. Nikam sir, could you continue your response, please? I'm sorry about the interruption. Yeah. Hello.
I think he will have to be unmuted. He is muted.
Withdrawal Nikam sir, could you unmute yourself, please?
If the host can unmute him. Then he can.
Host, please unmute Mr. Withdrawal Nikam sir. Somebody can call up sir and request him to unmute.
Okay.
Hello? Yeah.
Am I audible now?
Yes, sir. Yes.
Yeah. What Mr. Hitesh has suggested that there should be a proper director of the prosecution, I do agree with his suggestion. But in Maharashtra and in all the states in India, now there is a separate director of the public prosecution in view of the amended provision of the CRPC. Even in the Maharashtra, the director of public prosecution is functioning. What is happening so far, the appointment of a public prosecutor in the sessions court. Now there is a recent judgment of the Supreme Court that all of the public prosecution in the session court should be through the competitive examination, that is the true State Service Commission. So that problem can be resolved. The main problem is the coordination between the investigating agency and the office of the public prosecutor. That is the worrying of the problem. You see, normally the police officer investigate, detect the crime, but thereafter there is no rapport between the public prosecutor and the IO. As a result thereof, the accused gets the benefit.
Right, sir. So at this point, I would invite Mr. Banu Pratap Barke, who is representing the investigation side here. At least he has been a long-term police officer. So would you like to respond to this, please?
Yes, respected Padma Shri Nikam sir, Hitesh ji, just now they spoke about the prosecutor's role. But prosecutor's role comes after the investigation officer's documentation of the paper. It starts from the FIR, then Panchanama, then witnesses. And apart from all these things, then producing the witnesses in the court, producing the Panchanama in the court, producing the FIRs in the court, and then the trial starts after gap of many years, you can say, many months, you can say. So this is basically the time being framed should be there, that after lodging the FIR, investigation officer should complete the investigation in stipulated time, and which is not possible for the police force because of the non-police work. Non-police work is nowadays there. That main work of the police is the investigation and law and order. Apart from this, now you know, everybody on the panel and everybody listeners over here, they are aware about what police are doing. So my main question is that to the non-police work, since the FIR, prosecutor should be a police officer or attached with the investigation.
Wonderful. So we have the journalist Rohit Tatavle, who is having a kind of what we call as hawk's eye on how the system is working as the fourth estate eye. So Mr. Rohit, would you like to respond to these learned panelists' opinions? I also have Judge Alok Agarwal Saab from the NALSA giving very wonderful comments, which I will repeat for the audience. So would you like to respond here, Rohit?
Yes, ma'am. First thing is that it's very important to stop the media trial. And many times IO and also special people took contact to media person and told many things that he don't want to do. And that's why lack of problems of the investigation, problems open to all. So please first time to stop the media trial first.
Rohit, my personal experience has shown me that sometimes we use media advocacy as a strategy to strengthen the case or as a kind of protection against corrupt authorities, if there are any. Means at the bottom line is the issue that when you are a weak, a vulnerable kind of a person who is fighting against the system, in let us say torture case against the husband and in-laws, or in an unequal power relationship, let us say it's a tribal group or someone who is fighting, who is encountering a bigger powerful group in the village or in the place, then media
strategy is also one of the strategies of advocacy to keep the public opinion and to keep investigators under bay. What do you say? Can we completely rule out the role of the media?
यस मैम, एक्चुअली अगर हम लोग देखा जाए तो बहुत से मीडिया पर्सन्स जो है वो कहीं ना कहीं तो एफिलेट है. अदर देन वन थिंग दैट आयो एनी पुलिस स्टेशन, दो पर जो ऑफिसर्स होते हैं उनके इंटरनल राइवलीज एंड वो सब चीज़ों की वजह से वो बहुत सी चीज़ें आके मीडिया से शेयर करते हैं. इसका बेसिक एक प्रॉब्लम ये होता है कि एक प्रेशर बिल्ड हो जाता है. स्पेशल पीपी एंड उनके जूनियर्स हो या फिर अदर स्पेशल पीपी हो, सॉरी टू से उज्ज्वल निकम सर एंड अदर सर, बहुत बार ये देखा गया है कि कोई एक 10-15 ही पीपीज है जो या पूरे ऑल ओवर महाराष्ट्र और ऑल ओवर इंडिया जिनको एक डेकोरम दिया गया है. तो इसका मतलब ये तो नहीं है कि बाकी स्पेशल पीपीज कुछ काम नहीं कर रहे हैं. तो इसका ये होता है कि मेनी टाइम्स पॉलिटिकल पर्सन और होम मिनिस्टर हो या और कोई चीज़ें, ये लोग एक बात देखा जाए, अगर हम लोग अगर जळगाव की बात करते हैं 3 दिन पहले की, तो एक चीज़ हो जाती है कि अगर कोई भी एक प्रेशर बिल्ड हो जाता है, कोई सेक्सुअल असॉल्ट हो या फिर कोई अदर चीज़ हो, तो एक पॉलिटिकल पर्सन आके कह देते हैं कि हम लोग इस दिस स्पेशल पीपी को हमने ये केस हैंड ओवर किया है और आगे ये इन्वेस्टिगेट करेंगे और ये आगे इसको न्याय दे देंगे. ये सब चीज़ों की वजह से कहीं तो मीडिया का ध्यान वहाँ से हटाना है या फिर कहीं तो पब्लिक को ध्यान हटाना है. ये सब चीज़ें करते जो कन्विक्शन रेट है या फिर वो आयोग का उन्होंने जो पेपर बनाया, जैसे अभी बर्गे सर ने कहा कि जो पेपर्स बनाने हैं, तो सब फर्स्ट थिंग दैट कि एफआईआर रजिस्टर होने से चार्जशीट फाइल होने तक आयोग एंड स्पेशल पीपी का कोऑर्डिनेशन नहीं देखा जाता है. और ये सब चीज़ें क्यों होती है, तो एक कोई तो पॉलिटिकल प्रेशर आ जाता है और ये सब चीज़ें करते में मेन चीज़ एंड सोशल थिंग्स साइड हो जाती है और कन्विक्शन रेट डाउन हो जाता है. मैम
Wonderful. So we have a very technical suggestion here, very learned, experienced suggestion from Judge Alok Agarwal, where sir is talking about the prosecutor should have the discretion not to prosecute the cases with insufficient evidence. This will increase the conviction rate as well as help decongest the courts of unprovable cases. The investigation agency should certainly have the guidance of the prosecution. So sir is also highlighting the need for stronger coordination. And we can add one more point in the prosecutor's training, media management should also be there. So much so in police training, professionalism should be there. And prosecutors' initial suggestion to admit the case or not, to discuss with them with the insufficient case evidence instead of clogging the courts. Sir,
Madam, sorry to disturb you.
Yes, sir.
But that is exactly happening in US.
Yeah.
US after one.
Madam, I think that we are losing the important points.
Yeah.
Whether to prosecute a particular offender or not.
I will give you one example.
In England, Crown Prosecution Service is in charge of the whole prosecution. They take the decision. According to our Indian law, only the public prosecutor has the power to withdraw from the prosecution of any person under certain circumstances if he is of the opinion.
Yes, sir.
Proceed further again. So that is the discretion. And so far as Mr. Athole's grievance is concerned, it appears that he is personally making the grievance instead of talking on the subject in the debate.
Okay, we got it, sir. So we would request Advocate S.K. Jain, sir, to come in with the expert comments.
I think that, yes, may I start?
Yes, sir.
Look, we are talking about the coordinations between police officials and public prosecutors. I will take 2 to 3 minutes. I will give one example.
Yes, sir.
When our district judge Morir was there as a session judge, a case started, occurrence, investigations, charge sheet, and final hearing, everything was completed within 29 days. Iqbal Mujawar was the prosecutor. Nowadays, what happens that for having a coordinations, by the time the case come up for hearing, the investigation officer from Pune is either transferred to Nagpur or Ratnagiri or anywhere. So when the case is listed for hearing, unless there is a talk, discussions between the public prosecutor and the investigating officer before he opened the case, that how he has investigated, what are the important witnesses, what is to be examined. Nowadays, once he has lost the police station, his trial. So my suggestions will be that two things we have to see. Supreme Court has said that once the case is started, it should not be adjourned unless there is a very, very extraordinary time. Because day to day and within 4 days, the case can be finished. At the most, if there is some special cases, it may take 8 days, it may take 5 days, 10 days. But it should not be allowed to go for years together. Then the second questions will be that if the public prosecutor and the IO having a coordinations and discussions, that from what angle, then the presenting the witnesses, telling the witnesses what to speak, telling the prosecutor, because there are a lump sum 1,000 pages, 2,000 pages charge sheet, but the public prosecutor has no time to read everything. So he should be put the relevant part. So there should be a fixed time that during the posting of that inspector IO in that police station, the questions will be that how it can be possible. Suppose that it takes a year or 2 or 3 years by the time his transfer is due. Then whatever the cases he has investigated, he should be posted in the same city for some other post. Let complete all the cases which he has investigated. Then he should be sent out of Pune. Otherwise, the witness has no fear of the investigating officers. The witness has no competent training or instructions. And therefore, according to me, the first part is that there should be a proper, without delay, the trial of the case. Unless that is there, nothing can be achieved. We may have a 10 seminar or 20 seminars, whatever the reasons it is there. I will give you the one more example. That to have a more convictions or more particular parts are concerned, the investigation should be free from the political interference. Only because the political bosses wants, and therefore the IO or the police file the case or charge sheet, and it is bound to fail. Whatever we say, we have a 10 prosecutor or 20 prosecutors. So there is a less interference of the political bosses. Otherwise, the convictions rate will never increase. Then the third part, and I will stop it, that the police officers, if they are allowed to have investigations without fear and favor, I think that the Maharashtra police is the best police force, and you can get convictions even a 90%. But only when you are simply saying that they are the best, they are the best, they can't be the best. So stop political interference, allow the police to complete their job in their best possible manner, efficient manner, then only you will get the convictions. But to please the political basis, if the charge sheets are filed either by the CBI or by the state police, certainly the same thing will be there, because as it has been said that before court, दूध का दूध और पानी का पानी होता है. So political bosses के लिए अगर कोई cases charge sheet आती है, so it is bound to fail, or to please the public. Number of cases are coming because of public outcry. So many cases are coming, that why? And therefore, genuinely, if the police are allowed to do work, public prosecutors are allowed to give their opinion, and then the charge sheet file, I am sure that whosoever the defense lawyer may be, or police and the prosecutor will get 90%, 95% convictions. Thank you.
So, yeah, we are almost finishing this panel.
I will add only one point, madam.
Yes, sir. Yes.
Yes, Prakash Singh, ex-director of UP Police. He filed a writ petition in the Supreme Court, and Supreme Court ordered all states to implement police reforms.
Okay.
Half of the states are not yet implementing the police reforms. Just now, S.K. Jain sir said, what is required, that is a police reforms. It is very much required.
So we already have enough of reform ideas, like how Mr. Hitesh also pointed out on the Malimath committee report, and I pointed out on the Law Commission report. So, I mean, here I have 4 or 5 audience expert panelists who are not in the panel, but in the other panel, like Advocate Sampath Bulusu, we have got Colonel Radkar, Chandra Sen, Harish Shetty sir, who are all saying important points of how mental health is also important, and how there has to be better coordination, and there has to be less of political interference. Thank you, learned panel. Now we put the matter for polling. So, Atmaram, could you come in and show us?
Before you put it to polling.
Now this question will
go. Raina sir, would you like to say something?
Just a minute only.
Yeah.
Less than a minute.
Yeah.
I think all prosecutors who spoke and all police officers perhaps have missed that in 1973, the prosecution was separated from investigation.
Yes.
So we have the legacy of investigation with prosecution. What is happening, all of them conceal, is that when investigating agencies completes the investigation, without any law, they get the things vetted by the prosecution in a different room. They do not speak out that, which is an unofficial vetting. So there is a coordination, but not official coordination. My point is that law should be tightened there. We should have a perfect provision where we say, yes, the investigating officer, after investigation, should get it vetted by the prosecution, whether he is or not. So the transfer of case from investigation to prosecution is shouldered by both the investigating and the prosecution. There's a lack, and the internal coordination. External coordination can be many, mental health, other things. I will not divulge than that. That's not correct. 73 में हमने लिखा ही नहीं उसमें that ये होना चाहिए.
Sir,
Unofficially we do it, but officially it is nowhere.
Yes, sir. Point well taken. We are going to come out with a consolidated recommendation on the segregation of this, as you rightly said, on making law and order as expert policing part and investigation as expert policing part. As Burgess sir pointed out, already government is working on Raksha Shakti University concept and other things for professional policing. Now, before I move on to the recommendation polling, quickly, Sampath Bulisu in one line or in half a minute, if you could put your point, please.
Thank you, madam. Hope I'm audible. Good afternoon, all panel members and experts and audience. There is one thing we all have spoken about, the Directorate of Prosecutions. Yes, Section 25, capital A has been introduced in 2009 amendments to CRPC, and this thing has been brought in. There's yet another aspect that we are always missing, and we have been missing it so far, which I can continue with what Rena sir has said. There was a separate directorate for investigation that was envisaged in the 4th National Commission report, Police Commission report, and also in the 154th Law Commission report, which was chaired by late Justice Jayachandra Reddy at that time. Apart from having a separate prosecution directorate, we should also have a separate directorate for investigation, where the law and order duties for the police are kept separate, investigation teams are kept separate. And this is what I wanted to say, and that is something which has been spoken out long ago in the 4th National Police Commission report, which has missed. It has come in the 154th report of the Law Commission by Justice Jayachandra Reddy, and we have just implemented in 2009. There has been a long delay. This is what I just wanted to add.
Thank you, Sampath. So let's
can I come in?
Yes,
One small point.
Yes,
small point.
Yeah.
Yeah. Thank you. This is I would like to just mention one judgment of Honorable Supreme Court, State of Gujarat versus Kishan Bhai and others.
Yeah.
In this judgment, very clearly Supreme Court has said that the Home Department of each state will constitute a committee comprising with the police officers and prosecutors, and every acquittal should be vetted and appropriate measures should be taken to tighten the acquittal. So I think we have to also review whether these committees are functioning and how are they functioning, and then accordingly what kind of collaboration they are having. Number one. Number two, in CBI, there is a directorate of prosecution within CBI, and each matter is going to this director prosecution and then reaching, and they are filing the charge sheet later. I think we should also devise some mechanism so that there should be some coordination with the prosecutors before submission of the charge sheet. Thank you.
Point well taken, sir. Wonderful. So shall we move to the recommendation, Atmaram, quickly?
Yes, ma'am. Next recommendation is about attracting more talented candidate in the prosecution. And in the problem statement, stakeholder has stated,
the slide should move in that direction. Slide, please. Yeah.
Good lawyers are not coming in the prosecution because of less payment and less privileges are provided. And this has been supported by 93 stakeholders. Sub point to this is the need to provide independence to prosecution and investigation. I think maximum people have spoken about that. And for that, we have France model, we have German model, we have Japan model, wherein both wings are separate, partially working under the judiciary. And according to official statement in Germany, there is zero political interference in the prosecution and in investigation. So, word to ma'am.
Yeah, so we are moving to the polling here, or are we still going to dwell on the points?
We'll discuss points and then polling will happen in the end.
Yeah, but now we have discussed. I mean, the whole panel
Yes.
has discussed. So what do we do now? Do we move to the polling? And then are we done with this session? We move to the next session then. Before we move to the witness protection. Yeah. So the next polling question can we display after this point?
Ma'am, link has been sent.
Can you go quickly to the link has been sent?
Yes.
And, yeah.
And they can poll, and in link itself they can see the questions.
And can we move to the next issue, the fourth issue we have raised?
Till that time, maybe we can read out other issues, that there is need to increase number of PP. They are less in number. Expert has also spoken about need to increase the cooperation between police and prosecutor. But this is short-term suggestion. We are expecting a different prosecution and police wing. So for that purpose, as Sampath sir and other people have stated, there is need to create two wings of the police official. One is law and order wing, which may be under political bosses. Another is investigating wing, which is independent. And in other country, this investigation wing is working under the judiciary and not under political bosses. One of the short-term suggestion given by the stakeholder was that prosecutor should have the supervisory power than advisory power to overlook the investigation process. Next slide. And can you go to the next slide?
We have the next issue of need to create two wings of police, which
yes.
Raina sir pointed out. It's already
yes.
coming in. So could you highlight that, please, based on the decision of the Supreme Court in 2006? That we are coming into later, or are we pointing it out? Because the three questions are coming one after the other in terms of recommendation. Right?
Yes.
Yeah. So could you read those? See, dear audience, we have the questions now. I repeat, is there a need to increase the number of public prosecutors? Do you agree that there is a need to increase the cooperation between police and public prosecutors? As we already saw how investigation needs to be advised by them. Do you think there is a need to create two wings of police, law and order and investigation? Yeah. Would you like to highlight that, Atmaram?
Yes, ma'am, because in polling, it is seen by the stakeholders. Questions are seen by the stakeholder, but I can talk on that. Madam, next, previous slide, please. This one, next one, ma'am. So, okay, so, yes, so ma'am was talking about separate wing and cooperation between police and prosecutor and more number of PPs. So what is found in our data that PPs are less and they are getting lot of work, and therefore they are not able to manage their prosecution properly. So there shall be reasonable work given to the police official, and police officials are also busy with VIP and other duties, and therefore separation is required. Whereas PP are working on only prosecution, but lot of cases are given to them. That is one. Few public prosecutors are not permanent. There is temporary appointment, irrespective of 25 capital A, wherein the office shall be created for the prosecution, etc. So polling will happen on this question, ma'am. They are able to see the question in the link also, in addition to the PPT.
So, so far we have finished polling recommendation 6 and 7 based on this as well. Do you agree that there is a need for increased accountability and quality in prosecution? Is there a need of audit for delays in the prosecution? Because the advocate Mr. S.K. Jain pointed out how there was a time-bound one when the individuals were very alert, and how there is a kind of credibility associated with someone like Withdrawal sir in prosecution. Yeah.
Hello, ma'am.
Yeah.
By clicking on this yes and no, it doesn't show any symbol. So how I know I'm clicking yes or I'm not clicking no?
Technical
sir,
team, will you explain? Will you come in? Have you tested this Atmaram?
Chat box, you have a link.
Sir, for attendee, we are not getting link. Those who are in the panel are not getting link. Those who are attending the conference, they are having different link. On that link, they can go and there is option to click yes or no, and result of that is shown, sir.
Yeah, thank you.
So questions are repeated over there, and the yes no option is also there to click.
Yeah.
Because sir,
So
for
in addition to that, we have put up the question in the PPT.
Okay. So shall we move on? Because I'm monitoring the time. We are already having 10 minutes extra on this panel. So quickly, could you move, Atmaram? We are on the 8th recommendation.
Recommendations are ready. Can you show it?
So we are on the 8th recommendation, and with that we bring to the close of this panel. If any panelist or any of the learned experts would like to respond, we have had some experts coming in the chat box, especially Alok Agarwal sir said that if separation is to be maintained, investigation should have assistance of a lawyer, I think. Lawyer and prosecutor should have discretion not to prosecute. That's a good point in order to reduce the delay and to make it more professional and a very rational way of spending the court time. Then we have said investigation agency should be co-opted with at least one member of law and order committee to some sort of country. This is Colonel Radkar, very interesting. He was on the court martial of the military, so I'm sure he knows this evidentiary side. Thank you, sir. There are 3 types of prosecutors: cadre prosecutors, who are also called service PPs, and second is tenure-based prosecutors, and third special. Wonderful, Sampath Bulusu, good point, well taken. I was also wondering why there is a diversity in the way this office functions, because in Karnataka I had seen it in a different way. In Maharashtra it is in a very different way. Definitely, I mean, this also needs to be standardized. I wouldn't say uniform, but some kind of standardization needs to be there. Dr. Harish Shetty, would you like to respond quickly on any of the points as a mental health expert?
Done, ma'am, done.
Thank you. So this brings us to the end of this panel discussion, and I'm sure that in the polling, our more than 200 audience would have given their preferences, and I hope we have done a good job as what we call as experts body in terms of elucidating the issues to some of our young students as well. What the minister wanted was what we call as interested participation by the public. I'm sure to some degree we have achieved it, hopefully. Now there is somebody who is raising one more.
Yeah, this is polling result, ma'am.
Yeah.
Yes. So percentage is increasing because people are polling from that side. But maximum people said yes to first question.
Yeah.
Go to next question, please, because we have
next question, please.
Yeah, 100% people said yes to question 2. That is attracting more talented candidate in prosecution. And independence of this prosecution and investigation office shall be provided.
See, for example, now for the benefit of the panel, I think Mr. Jain would know about it, Hitesh Jain, that there is a committee which is working on the perks of the judges. And that committee has opined that to attract talented students, we need to revise the perks. Similarly, as it was already pointed out by many experts here, we may need to attract talented people. And for that, we will have to have a commission which will look at the current perks and emoluments of this office. Yeah. And the nature, as Sampath pointed out. Is there a need to increase the number of people? See, there is 100% consensus on this.
On cooperation also.
In the interest of paucity of times, instead of discussing the results, we can push ahead with the session.
Yeah, now let's go to the next session. So this is just the indicative poll. So we need not display every result. Indicative that how the public have been convinced about the seriousness of the issue and the technicalities. Thank you, panel, and thank you all the experts, and thank you, Dr. Shelke, for a very structured presentation. And there is one recommendation. Do you agree that there is a need to have more forensic labs and forensic experts and computer experts? How does this come in? Because we want to have more conviction rates. Yeah.
Yeah, according to some of, may I, ma'am?
Please.
According to some of the stakeholders, they are not getting report from the forensic lab and computer lab. It normally takes 1 or 1.5 years, and they have time to submit their charge sheet, that is 60 and 90 days. So that was the problem stated by the stakeholder.
So about that problem, quickly, if any one or two people want to respond. So we have many more recommendations from 8 onwards on comprehensive training, time-bound trial, need to improve courts and court infrastructure. It is the given that all of us know that there needs to be more investment on justice system, which is one of the fundamental human rights. And time-bound trial, for example. So this has been already highlighted, panelists, in a very symbolic way. Do we need to get into a digital system, paperless system? Although phase-wise digitization of the courts is happening, maybe seeing the day of paperless has been exacerbated by COVID crisis. Should the courts rely on scientific tests more, like narco-analysis, more objective tests than the subjective, adversarial kind of approach in a human presence kind of thing? This also, I think this question has been answered in the COVID crisis in a way that it could be openly thought of. Otherwise, India wouldn't have thought of these questions. So I think we don't have so much time to go to all the questions, but the gist is received by our audience as well as panelists. Thank you, one and all. Let's move on to the next panel. Our plan was to give 3 minutes bio break. So could we take a 3-minute break? It's not healthy to sit in front of the machine all the time. We invited you, and since 2:30, you're there. So could we take a 3-minute bio break and begin the next session after 3 minutes, which will be 4:40. Is that okay? Yeah. Thank you.
कहाँ दिल्ली क्यों क्या हो गया अच्छा तुम कहाँ हो क्यों गुड़गांव क्यों क्या हो गया हेलो क्या
Good evening. We are back after the break. So the next session is going to be on witness protection, which is the second issue we have picked up. I hope all the panelists are with us. Is there anyone yet to return? Yeah, taking cue from the first session, in the first session, we have had experts talking to us about practical issues they have faced in prosecuting or defending. And then our researchers have, especially Dr. Shilke and his team, have provided very good, well-researched areas which need reconsideration. And the panel has brought in a lot of other research which is already present in this country. So now we move to the second theme. The second theme is providing witness protection. And I invite the panelists, first of all, our esteemed ladyship, Dr. Shalini Phansalkar Joshi, our distinguished visiting judge scholar here. Mr. Alok Agarwal, the research and policy advisor of National Authority for Legal Services. And then we have Advocate Latika Salgaonkar, legal academician and an advocate. Dr. Harish Shetty, the psychiatrist. Advocate Hitesh Jain, once again, our alumna as well as a very distinguished lawyer practicing in Mumbai High Court, and Mr. Banu Pratap Barge from the investigating officers. I mean, he's the retired ATS chief, ATS officer actually, who was in Pune as ACP. Now with that, I'm very happy to invite my co-moderator, Professor Shirish Kulkarni, to quickly present the recommendation proposals. Yeah.
Thank you very much, ma'am. As been already highlighted, just wanted to mention that the witnesses are the eyes and ears of the justice. So in considering the same, we went on to carry on whether the law is there. So we found that the witness protection scheme, though we talk it as a scheme, but being from the point of view of law, we came across whether in the light of the questionnaire which we got from the stakeholders, we realized there are some problems that the hardship is faced to the witness, lack of respect is given to the witnesses by the law enforcement agency. At the same time, there is a detailed stretch examinations and cross examinations, waiting time in the court, no special place to sit, so there is no such dignity to the witness. And that's the reason we, from the data collected, we found that 56.6% of the stakeholders believe that we need to bring this recommendation. So after analyzing the data, we found that there has been a uniformity that there is a need of a dignified treatment to be given to the witness protection, as well as availability of special waiting rooms in the court premises, respectful behavior towards witness, free traveling, government-owned means of travel, which is missing if we compare to the foreign models, including the Australian model, which is very best. So in terms, this particular thing has been highlighted and there's an urgent need. So on this, we would like to invite suggestions of the experts. They can throw light on that so we can give for a better recommendations to the concerned government. Over to the panelists.
Yeah, I request Madam Justice Shalini Phansalkar Joshi to come in and respond.
There can hardly be any two opinions that witnesses are required to be given dignified treatment. There should be some special waiting area for them in the court premises, and everyone should be respectful towards them. The question is about the infrastructure upgrade. I mean, there is hardly any, sometimes there is not sufficient space for the chamber and court hall also. So we know the things at present. So availability of special waiting rooms in the court premises, it is a must. And respectful behavior, yes, it has to be given, because ultimately they come to assist the court and therefore they deserve all the respect, and that is 100% yes.
Right, ma'am. So Shirish, would you highlight the next point? And here we are going for the poll point, which is the recommendation that there is a need to incorporate dignified treatment with all these infrastructural facilities and providing them expenditure remuneration, no one takes interest in the justice system because there are delays, they have to come and wait. So as a result, the cases fall through, and even the delays result in forgetting the crucial details. Once again, there the briefing of the witnesses by the prosecution, relationship building, all these points come. I mean, I remember in women's cases, the kind of work we used to do at the grassroots used to reveal that none of these issues are distinguishable or strictly separable from the earlier part that we have taken. These are interconnected. Anyway, I request Kulkarni sir to move to the next idea. Yeah, please.
Yes. So with the first poll, which we have already done, the next is we found from few of the stakeholders that when the time being provided by the witness protection to hold the trial, they complained about that there was an absence from the work. So there is no such support. Then the lack of prescribed provision for leave from office is not taken care of the scheme, which is
in the form of a law. So we went on to talk about that is not sufficient to check the problems of not only witness but hostile witness also. So the problems which we highlighted, the justification, on that basis we got 56% of the stakeholders. They want that these are the urgent things needs to be done to make the scheme or the law foolproof. Yes. Over to the panelists over on this issue, please.
So I request the other panelists, maybe I would request Mr. Alok Agarwal, Research and Policy Advisor to NALSA, to come in and respond, alongside Advocate Latika Salgaonkar, followed by Mr. Harish Shetty, Advocate Hitesh Jain, and Mr. Banu Pratap Barge. Any one of you can take the cue and take it forward on these two issues and earlier issues that we discussed. We have a few more points. Yeah, please.
Good afternoon, everybody. Am I audible, ma'am?
Perfect.
Yes, sir. Yes, sir. You are audible. Yes.
Yeah. Thank you. You see, these are the hardships that he has to take leave from office or otherwise loses labor charges in case he's a laborer. But so the only solution to this can be to have different time slots for different witnesses. See, the court should fix a lesser number of cases which they can manage. They should have in advance the list of witnesses who are supposed to come, and then allot time slots. On this point, I would say only that. Time slotting is necessary.
Okay, Advocate Salgaonkar, ma'am.
I would say that the witness protection should start right from the police station level, where investigation is done and statements are recorded. Because as we see that the witnesses are hardly aware, or perhaps they are scared, as our experience as a part of a women's NGO, when women would go to the police station as witnesses, either maybe the prosecutrix herself or maybe witnesses, they are not aware that they will be taken care of, or there is some kind of protection for them if they give the statement. So, and as the statement given at the police station forms the foundation of the trial later on, where the prosecutor has no control on it, there the witness protection should start right from the police station level. Secondly, as I see that as today, the protection or the right of an accused to get police to get legal help or to call his relatives is exhibited in every police station in Maharashtra. Similarly, the witness protection scheme, or there is something like witness protection, is not known to the general public at all. And why people are faltering or why people are reluctant to act or appear as witnesses is because they are scared that later on there may be repercussions on them, or there may be threatened by the accused, etc. So if the witnesses are confident and the witnesses are sure that if they speak the truth or if they give the correct position as related to the crime, they don't have anything to worry or they don't have anything to fear. I remember in 1993 or 94 when there was a Jalgaon sex scandal trial in Pune, and the trial was shifted to Pune, and at that time strict secrecy was maintained about the whereabouts of the girls who were raped of the witnesses, and even as part of women NGO, we were not allowed to have any access to them to help them. So that if the police can, that time the witness protection scheme was nowhere there. But even then the Pune police had acted very well and the witnesses were protected to the ultimate. So I feel that the witness protection scheme, public in general should have a complete idea, or at least a basic idea, that witnesses will be protected if they come out with the truth.
Okay. I would be very interested in knowing the views of Dr. Harish Shetty. Any of the cases that have come across where witnesses have additional trauma or harm experienced in the process?
Absolutely. Ma'am, what is very important, hi everybody, good to be here and I'm learning a lot. What is very important is protection is not physical protection. It is emotional protection also. What happens to the witness across time? Initially, if he is a true witness, there are false witnesses also. There are false witnesses which are brought by the police also. If they are true witnesses, they are very enthusiastic initially probably, and then there are changes happening in the witness. One, he gets bored at the length of the case. Number two, he also gets very scared because the relatives, the accused, really go to the witness and say, please save my son, he was innocent, he's done nothing except for one offense. And they go and meet the witnesses in the family. And there's a lot of dynamics happening in the family of the witness where the wife says, Abhi tum kyun isme padta hai, jane do usko. And then a lot of pressure and coercion happens indirectly by the police. And I have seen that happening. And there, if you say that hostile witnesses should be punished very, very badly, I don't agree with that at all. Now, at the end of the case, as the case comes up, some witnesses have existential dilemmas in their mind. Atta काय झालं आता 10 वर्ष झालंय आता सोडून द्या तर काय आता एवढं लांब खेचायचं the guile in our Indian psyche is very poor and remaining firm across time cognitively is not easy. So here what is very important is a witness emotional protection is important. If the court and the judicial system and the law enforcement system has an emotional arbitrator who keeps in touch with the witness across time to maintain his poise, etc. So it appears very funny to some. But I think it's important to bring in that aspect so that the witness remains where he is, he's supported and is protected by threats from the others. And the law enforcement agencies also take a strong recourse to any threat to the witness immediately, not after 10 years. So there has to be a system which which provides emotional protection to the witness and not only physical protection. If you provide emotional protection, he physically also becomes much stronger. And that could be done by NGOs, it could be done by so many others, but it has to be systematized. Harsh punishment to a witness when he becomes hostile is not advisable because the background of he becoming hostile is not the same for all witnesses.
Dr. Shetty, your response along with the Advocate Latika's response brings to my mind one experience of mine which I was told. In 1998 in Ireland, when bank robbery happened in the broad daylight, when students were queuing up for the ATM, and then it happened in fraction of a second, and the police took everybody's name, and when they came back to their individual dwelling places, the police called them and asked, did you feel traumatized? Did you feel something strange? And next day again they called and they asked, did you get any nightmare? So as ma'am rightly pointed out and you pointed out, the trauma of witnessing a crime is taken very seriously in these countries, whereas we take it for granted here. So if our system has to be very conscious to this, then all these points have to be taken into consideration and the police have to be very proactive. So I'm curious to know from Mr. Barge as well as Advocate Hitesh Jain, their views about this witness protection dimension.
See that first of all, there are witnesses, means different type of witnesses are there. Eyewitness and then punch witnesses. Just now Mr. Shetty said that if you go through some cases, like in cases registered under the ITPA Act, repeated panchas, you will come to know that the repeated panchas are there. In all cases, in each cases, some same panchas are there. Mainly, eyewitnesses are more important in these serious cases. And I think witness protection is not needed in each and every case. It is very limited to very, very low number. That like Indira Gandhi's murder case is there, like 9/11 is there, that 26/11 is there. In that type of cases, if eyewitnesses are there and they need protection, then only that protection is given. The protection is given as per the TAR, means traffic analysis report given by the concerned DCP or concerned additional CP. And then only this protection is provided. And main lacuna in this case, this act is that this protection is provided only for 3 months, not more than 3 months. Limited funds are there. I think, I don't know about the court, and court should look into this, that key protection fund should be available to the police or to the government. Government should see that this protection, whatever protection is given for that funds, accommodation, name change, whatever legal formality, it should be completed by the government, not by the police. Only police can recommend that these witnesses should be A category, B category or C category.
Wonderful. So anyone else would like to comment, or can Shirish proceed further with the recommendations, please?
Ma'am, here I would like to say something.
Yeah,
one of the problem is lack of specified provision for leave from office. I mean, they have to take the leave. So like in jury trial, you know, juries are considered to be on official duty when they go there and attend the case. So here also independent witnesses like Bansar, I mean some other persons, if they show the court summons, then they should be permitted to take the, I mean, it should not be considered as a leave. That can be also one way of, you know, making themselves available. Because nowadays, you know, on one date only they will have to come. That is no guarantee, considering the number of cases on the daily board, considering the availability of PP, defense counsel. So at times they may have to come again and again. So lack of specified provision for leave is really an issue for some. And we don't work on holidays like Saturday, Sunday. So they have to take the leave and come. So if we like jury trial, when the juries come and they are considered to be an official duty and it is not considered at least as a leave, similarly, we can also make some similar such provision.
So we'll make a recommendation.
Professor Gurpur, one small point.
Yeah.
There is a phenomena, as we all know, stock witness. And perjury provision should be strengthened, because you see, this is happening because of two problems. One, the police public rapport is not good, and several times the punch witnesses are being made, I mean forcefully they are being made, or witnesses in other cases. So what I would like to suggest, that we should develop some kind of mechanism so that you see this stock witness phenomena could be curtailed, as well as also the perjury procedure can also be initiated against those who are giving the false witness, and the attitude of the police to reach out to the people so that people are encouraged to volunteer and become the witness. Thank you.
Wonderful. Yeah, these are.
May I make one submission?
Madam,
can I make one submission here?
About this
after he speaks,
scheme is concerned,
yeah.
About this witness protection scheme is concerned, not much awareness has been created. Like for example, the point which Mr. Burge made, that the scheme only provides for protection only for 3 months. Second, you have to maintain the confidentiality, but there are no penal provision as to if there is a breach of confidentiality, how do you deal with such provision? Third is about the TAR, the threat analysis report. They themselves are prepared by the persons who are interested. Now, suppose if the person themselves are compromised and there is no independent body who is going to prepare the threat analysis report, and it is only going to be limited to the celebrity cases, then it is going to be a problem. Now, as far as the witness protection scheme is concerned, it basically was a scheme that was formulated by the Union government, and the Supreme Court, by exercise of its power under Article 141 and 142 of the Constitution, declared it as a law. So what will be important is that we have to create awareness. It is not limited to specific case. It is available to every cases. So I think we have to make the situation about the awareness, and second, a specific suggestion that the protection which is afforded only for 3 months, that has to be afforded for at least a year or two, because the trials are not completed in 3 months. Usually the trials are completed in 2 to 3 years.
Ma'am, can I comment on one submission?
Yeah.
NALSA can really work in creating awareness, because that is very important, as Jain has rightly said. Hardly few people know about it. So NALSA can create legal awareness, and yes, it should be for some more time, because within 3 months it is just not possible to conclude the trial.
Yes, ma'am. Now
Thank you, madam.
we have
Madam, can I-
missionaries in NALSA. Agarwal sir, please. Yeah.
Yeah. Ma'am, first thing is that, I mean, of course, it is rightly pointed out that it can't be only for 3 months. In fact, the threats can be for preventing deposition, and the threat can be as revenge also. So in some cases, it may have to continue for life. So that is the one thing. Secondly, as it was said earlier, that the witness protection should start from the police station. I would say that first thing to ensure is that the police records the statements correctly. Today, if the police introduces a false witness and the witness comes in the court and deposes correctly, then he is termed hostile. So that should not be the case. Thirdly, when in very serious cases, the scheme also talks of relocations and concealing the identity and everything. My respectful submission here is that apart from thinking over it from the criminal justice system point of view, we should also think about it from the point of view of human rights of the witness.
Yes.
Totally, I mean, somebody losing his identity completely, not being able to do what he wanted to do, not totally cut off from family members. I don't know, maybe, and only because he was a chance witness. He just happened to be there. So there has to be some solution to this, that there should be no threat also, and he should be able to, probably what I am hinting at is, it may sound odd here, but maybe, can a witness have a right to silence?
Right to?
Silence.
Silence. Okay, wonderful.
I don't want to give evidence.
Yeah. So quickly, Shirish, can you move to the next point? Because we have a few more points there under this subheading. Who is moving the slide? Hello? Yeah.
Ma'am, the other point which we wanted to talk about is in relation to the problems that the disclose of identity, which sir has already mentioned. So the family provisions regarding the change of identity of the witness are incomplete. Overburdened police forces are not enough to implement the provisions of the scheme, and accordingly video conference is not at all used often to record testimony of witnesses in certain heinous offences apart from sexual offences. Availability of infrastructure for top security facility for witnesses is missing. If you go through the problems, the justification is the recommendations. The stakeholders are saying 92.5% of the stakeholders believe that we need to incorporate in this scheme to make the witness protection effective.
Okay. So there's a scheme which was rolled out in 2018. How far is it rational? So this is the point I would request the learned panelists to respond to.
Over to the panelists. Thank you.
So are we done with all the data that we have brought to the table, or is there any more slide? We're done with the data. So now the polling will be on which theme, which line?
Yes, ma'am. Rupal ma'am, will you show the Rupal? Yes, ma'am. Rupal ma'am is connecting to the polling. Yes.
Yeah. So the polling will be on these questions. Do you agree that there's a need to incorporate dignified treatment? And then we go on the other sub points, which we talked about the scheme and what the learned panelists brought out. When should it begin? Should there also be not only physical protection, but as Mr. Shetty said, the counseling from the beginning? And as I experienced, I told the experience from Ireland, and as Latika ma'am said, and as Justice Madam mentioned, that there has to be a kind of official leave sanction and also protection given. So there are many dimensions which are going to be put for the poll. As we move on to the polling, and as the polling is happening parallelly by the respondents who are outside of the panelists, I also thank all the panelists, including Justice Shalini ma'am, and Mr. Alok Agarwal, Advocate Latika Salgaonkar, Dr. Harish Shetty, Advocate Hitesh Jain, and Bhanu Pratap Barge sir, for wonderful contribution, and also some of our experts like Professor Tiwari, etc., and others. Now we move to the next panel. Over to the computer, please.
Thank you to all the moderators and the panelists, esteemed dignitaries that are engaging in this public discourse. We will now move on to the next panel, panel C, consisting of the theme on advancing victim protection and rehabilitation. Now, in the interest of time, we are going to post the link for polling simultaneously as the panel progresses. And as the recommendations are made, the relevant questions would come up on your polling. So the audience members are requested to continue polling and expressing your opinions on the recommendations simultaneously as the discussion is progressing. So to moderate this session, I would like to invite once again Dr. Shashikala Gurpur ma'am and Ms. Chaitrali Deshmukh as the co-moderator.
Yeah, thank you, Ms. Lasya. Now, taking the clue from the previous presentation, there is one more response, which is Sampath Bulusus, who says that witness protection should not end once the trial is conducted. It should continue beyond. I mean, we keep reading about such precarious situations. Now, we have the important theme of advancing victim protection. From witness, we are moving to victim. So prosecution, witness, victim. So for this, I invite Ms. Chaitrali Deshmukh, who is my co-moderator. She's a journalist, she's a visiting faculty with us, and she is also our PhD scholar who is researching on the special issue of children. I invite my esteemed panelists, which includes our judge scholar, Justice Shalini ma'am, Dr. S.C. Raina, the former Vice Chancellor of Himachal Pradesh National Law School and current Dean of Kids Law School in Bhubaneswar, Advocate S.K. Jain sir, Mr. Sunil Chauhan, the Director of NALSA, Dr. Harish Shetty once again, and Advocate Latika Salgaonkar. I request Ms. Chaitrali to present the proposed recommendations, our justification, and what our field data among more than 100 stakeholders as a community-based survey showed. Over to you, Ms. Chaitrali.
Thank you, ma'am. Ma'am, the criminal justice system is often seen as a zero-sum game. Someone loses, someone wins. The accused seek acquittal and the state, which represent the victim, seeks conviction. Unfortunately, in this process, the victim is oftentimes treated as afterthought. The next recommendation based upon the data collected from the stakeholders are VIS should be introduced in India. VIS, that is Victim Impact Statement, should be introduced in India into consideration the social, economic, psychological and psychological aspect. 70% of people responded that VIS should introduce in India. The second important aspect was considered under Section 357 of CRPC, where judges' discretion to grant compensation. It is seen that 61% seen that judges do not follow such provisions, and delay of payment was the section was asked. 73% of people stakeholders replied delay in compensation result in inconvenience to the victim. Okay. Thank you, ma'am. Over to you, ma'am.
Thank you. And there is also a third recommendation that there's a need to strengthen the coordination between state and central government. That mainly they say that this fund is resulting in disparity, there is ineffective approach, etc. So with all these 3 points which have come from our field survey, I request the first panelist, Dr. Shalini ma'am, to respond.
There is absolutely no dispute that there should be uniformity in the victim compensation scheme, and that was taken note of by the Supreme Court also in the Taken case, Taken alias Tekaram versus State of MP in 2016 itself, then in Nipun Saksena's case in 2019. Such scheme was formed, took notice of absence of an integrative system and directed NALSA to constitute a committee to prepare model rules for victim compensation as regards sexual offences. So uniformity has to be there, the compensation has to be paid in time, and the experience definitely shows that when it is left to discretion, sometimes the discretion is not exercised, And therefore, Supreme Court has also in these two cases said that it is not only the power of the court to award the compensation, but it is also the duty of the court to award the compensation both interim and at final. And if the court is not using this power or duty, then the court has to assign the reasons. So at present, there are sufficient safeguards as regards the award of compensation, amount of compensation, several criteria are also there. The only question which, some point which troubles me is about the, sometimes compensation is made dependent or conditional on victim testifying or victim testifying truthfully. In some of the schemes of compensation, there are several schemes, Manodhairya is also there in Maharashtra. It is said that unless the evidence or deposition of the victim is recorded, she will not be paid compensation. In some schemes, it is also stated that if the victim turns hostile or has not supported the case, then if any compensation is already paid to her, that should be recovered. So I think that neither the Act, nor the scheme, nor CRPC, nor rules, nor the POSCO Act, nowhere it is said that payment of compensation is dependent on the victim's deposition. So we should, in the schemes which are at variance, we should not make it dependent. That is one more aspect. Compensation should be also adequate, fair, reasonable, and interim compensation is paid in very rare cases. This power is to be exercised by the court suo moto also without application. So again, it needs to be created, more awareness, because judgments are there which give its direction. But despite that, if the power is not used, then we have to create awareness and training on sensitization on this aspect. That is what, not only the victim, but the public prosecutors, her private counsel, his or her private counsel, everyone should, invite the attention of the court to this very laudable provision of payment of compensation. That is what I feel.
Thank you, ma'am. And here there is two dimensions. One is the protection and the other is rehabilitation. And where does the compensation come in? Does it come in terms of a third, in the three-pronged approach? And how is the actual execution of the compensation happening? So these were some of the investigations that we did with the stakeholders, and that's how we received those responses. Thank you, ma'am. I will request Mr. Raina, Dr. Raina sir, who has been a long-term researcher and a scholar in multiple fields, especially criminal law, IP, etc. So, sir, we would like to know your views in this context.
Thank you, madam. May I say that there is some, the first slide you showed is with respect to protection. A small question before I answer this one. As to who will protect the witness. The problem is that I think the stakeholders have not seen the American model, where a separate agency has been created. The police of India is not trusted, not worth trusted. See what's happening in UP. Even if a witness is given to them, is she or he protected? Anyway, with respect to compensation, we had a scheme of 357, which was perhaps a scheme of give and take. And that scheme has been taken over in 2008/2009 by adding 357 capital A. Though that's not perfect still, because the discretion has been given to the magistrate to award compensation in most of the cases or in all cases, but the magistracy is still not ready to do so, as it is in case of probation. As in case of probation, 360 CRPC says that such people who have 2 years or less offense committed punishment should be given probation. And in case they do not give, 361 says that the magistrate should record the reasons. With respect to 357A, the magistracy is still not ready to give compensation. That's why the discretion even given to them is not being applied. The third thing is that we are signatories to the United Nations Charter on all issues of compensation, which includes three things: compensation, rehabilitation, and assistance. We are applying only one in 357A. That's compensation, what Madam was speaking. Whether we use money, we leave them just like that. The rehabilitation part is not part of 357A. It's nowhere there. That's very important. God forbid, for example, for a rape victim, we give 2 lakhs to her. Will she be satisfied? Unless there's a rehabilitation. Who will rehabilitate? I have seen working with an NGO that NGOs start rehabilitating them. How long will they do it? There's nothing as government scheme of rehabilitation of victims. The assistance is given in the form of restitution. We are still languishing between two words, compensation and restitution. We have restitution, that is some saucer. We may give 500 rupees to them to be silent. Okay, this is that ointment you can apply on the wound. But compensation is to be calculated on a certain specific way, as do we calculate in labor laws, that the time period one can live, the capacity of the person to earn, that's not being applied. There's no mechanism. I think the stakeholders should make a recommendation as how to compensate or compound compensation by the magistrates. And their scheme, as we have in Motor Vehicles Act, the compensation should be calculated in terms of age, in terms of earning, in terms of social status, in terms of everything, whatever it is. That should be mandated. And every judge should have a mandate to grant compensation. I don't say that in crores of rupees, as the scheme suggests. But not giving is a problem. Rehabilitation is zero. Who will give it? With respect to what Madam Gurpur says, that state and central, there is a scheme of creating funds. One is that philanthropic people can donate to that fund. Other is the fine which we actually charge from the people, that also comes in crores of rupees. And the third is that center or the state may give grant to create a corpus. The problem in Hindustan mein hoti hai ki paisa baante kaun. There's a big problem because money is everything for us. That the problem of distribution of that was actually solved when we passed a small memorandum in Bangalore. We call it a declaration of 1986. And I think the Professor Tiwari will bear me out. He was a young man. That this was the Victimology Society which passed it, that the government officials should do it as we have a legal authority. The Legal Services Authority should take the responsibility of distributing such compensation to the victims, which the court has granted. If the court has granted to me 5 lakhs, court will not give it to me. Court may pass a judgment, then some nazir or some clerk has to give it to me. The court should pass the judgment and pass it on to the Legal Service Authority. The Legal Service Authority should come to my rescue and give money to me. Ab to wo bhi nahi hai. Ab to Modi ke zamane mein, it should be a digital process. I should have an account and the money should directly go from my court to my account. That's easy. These are the things which we need. I think the recommendation should be in those lines or in that direction.
Actually, in this respect, Madam, I would like to add here something. 357 says, 357A says that court can recommend the compensation. Whereas under POSCO Act, POSCO Act and the rules which are framed very recently in 2020, they are all, there the court has to direct the DLSA to make the payment of compensation. And from the receipt of that order, the payment has to be made within 30 days. So the POSCO Act provisions for payment of compensation are very, very elaborate, especially the rules. They let down on the basis of which the compensation is to be paid, who has to pay it, and how it is to be paid within a certain time limit. It also provides for legal aid, medical counseling, everything, as regards restitution point. And in these one-stop centers, they will be really useful. They will be like victim examination suites, which we have in England or other foreign countries, where once the victim goes, she gets everything, and from time to time she will be provided with the counseling, medical aid, legal aid, medical examination, everything. So these one-stop centers can be, if they are really implemented in the spirit in which they are meant to be, they will resolve majority of the problems. So that is what, but we should implement it.
I understand. So both of you have given such practical suggestions. Here we have Dr. Harishetty in the chat line saying that burden of disease can be measured with mental trauma, emotional disability can be measured too. Compensation needs to include these. Compensation should include counseling costs as well. So when the judges are calculating the compensation, some of these factors could be given as a checklist and they could seek expert advice, or the checklist could be made with expert advice, like how the NGOs helped the courts in Mumbai initially to develop this parental planning in case of alienated parents. We could have such expertise coming in. Now I invite Advocate S.K. Jain sir, if you have any point to contribute here to victim?
I need to make one point, ma'am. I think
Yes.
what is also important is unlearning of the judiciary. Compensation depends upon the attitude towards a crime or an event by different judicial officers. We have found that though there are scientific ways of analyzing,
Yeah.
we need to bring about the harmony and equality among the entire the judicial officers to make a scientific assessment of what
Absolutely.
Scientific assessment.
Yeah, yeah.
I'm an example in the marriage courts long ago. Now it is very good. Long ago, it could depend on what the judicial officer felt the girl would need or the boy would get on that has gone away. But there's a lot of social stereotyping which happens in the minds of the cops and other law enforcement agencies also. Itna paisa kyun chahiye? So that has to be purely scientific.
Agreed. So how do we bring that scientificity into that? We have good examples evolving out of judicial practice as of now. So those best practices could be emulated. I would request Mr. Sunil Chauhan, since this NALSA issue also came about. Sir, could you come in and give us your reflections, please, on the points that has been highlighted by empirical research?
Good evening to one and all. Very happy to be here. First of all, I would like to throw some light on this thing. I'll just take two. As far as section.
1 second, sir. The technical organizers, could you just see whose mic is on and they're talking? Could you mute their mic, please? Okay, please go on, sir.
Section 357 contains the accused paid compensation concept, and section 357 capital A contains the concept of state paid compensation. Under section 357, compensation can be granted only when there is conviction, and that too, it is determined by the court and paid by the accused. As far as section 357A is concerned, compensation except in cases is not determined by the court. It is recommended only. The determination is made by the District Legal Services Authority, and disbursement is also made in most of the states by the State Legal Services, District Legal Services Authority. Now coming to section 357, there is no provision of interim compensation if you read section 357. So that is something which should be added. And if you see section 357 subsection 3, it says that if the fine does not form part of the sentence, then the court can grant compensation. But if you see the serious offenses, then the serious offenses in serious offenses sentence contains fine. For instance, if you see section 325 only or 326, the sentence is like this: imprisonment and fine. It's not or fine. The court does not have the option to deduct confine the sentence to the imprisonment only. So does not form part of the fine is something which the embargo which needs to be taken out of subsection 3, section 357. Or if this embargo is not taken, then under subsection 1 of section 357, compensation is to be paid from fine. If you see the power of fine of the magistrate can fine up to rupees 10,000, or that power of fine needs to be substantially increased if the embargo under subsection 3 is not removed. One thing. Now the most problem, the biggest problem which comes while making the recovery of fine, which is ordered under section 357, is this: that the accused does not pay. They prefer to undergo the sentence in lieu of the fine imposed. So for this, my suggestion would be that when the convicts, they do earn wages in the jails, their wages should be deducted and the fine should be paid out of the same. So this may be also added in section 357, one thing. Now coming to section 357A, there are 4 scenarios which are covered by section 357A. 1, in case of conviction also compensation can be granted. In case of acquittal also, third scenario when the accused is discharged, and the fourth scenario when even the offender is not traced out. In the first three scenarios, that is conviction, acquittal, and the offense is not when the accused is discharged, the reference, the recommendation should come from the court. One thing. And in the last one, application should be moved before the DLSA. Meaning thereby that section 357A does not contain a provision where the suo motu cognizance can be taken as far as the compensation is concerned by the DLSA. So this is something which must be added in section 357A, that in case of interim compensation, at least suo motu compensation, suo motu notice should be taken by District Legal Services Authority. Now coming to the interim compensation, although subsection 6 do contain the word interim relief, but there is a lot of vagueness in the same, because you know that somehow relates to the medical relief or something like that. So very specific provision of interim compensation should be inducted, should be introduced in section 357A also. Now coming to the handling of funds. In most of the states, in some of the states, what we have observed, that the compensation is determined by the District Legal Services Authority, but it is paid by the executive. So once again, the matter goes to the executive for disbursement of the compensation. So it causes a delay of several months. And in most of the states, the practice is this, that the funds are kept at the disposal of State Legal Services Authority and District Legal Services Authority. And in such a scenario, what we have seen, of determination of the amount, the disbursement is made through check. So this is something, who will handle the funds? If this can be clarified under section 357A, then it will, avoid the delay in disbursement of the funds. Now coming to the sources of funds. What we have seen that there is often a gap between the amount awarded and the amount disbursed. If you see the, entire India. This section specify the sources, because primarily it specify only the state budget, and that is the prime source of source for victim compensation fund. But apart from that, it shall also specify the donations if permissible by state government or the central government. It should also specify the CSR also. CSR fund can be utilized. That will bridge the gap between the disbursement and awarding of them. And another thing is wastage of funds. Most of what we have seen that in some of the states, they do have certain criteria that it has to be deposited in the fixed account of the victim, but some of the states do not have such criteria. So it leads to the wastage of funds, and actually the fund is not utilized for the rehabilitation of the victim. One. And the last point which I would like to say is that, under section 357A, all the states frame victim compensation schemes, but there is lack of uniformity, meaning thereby for the same crime, the victims will get different compensation depending upon their locations. So uniformity is something which is missing. Some of the states have adopted the definition of victim as given in the CRPC. Some have framed their own definition. So in some of the states, the dependents and legal heirs are not included as victims. In some of the states, they are included as victims. So there is no uniformity. These are some of the few points which I would wanted to highlight, and this can be rectified by bringing some legislative change by amendments in section 357 and section 357. Thank you.
May I say something on this?
Sir, it's a view from the ground, because there is one more advisor from NALSA who is telling Mr. Alok Agarwal that compensation is being adjudicated and distributed by legal services authorities in most of the states. Over to SK Jain, sir, for your intervention, sir, quickly. Yeah.
So in my view, so far as the provisions for giving compensations to victim is already there. I want to add one more thing, that when at the beginning of the trial, in the case of before the magistrate court, while framing the charge before the sessions court also, when the prosecutor opens the case, if he feels that it's a good case where there is a requirement of compensation to be given to the victim, along with the framing of the charge, he can request the court that this is a fit case prima facie that victim has to be compensated. And before the accused is called upon to face the trial, considering the financial resources of the victim, even the interim order can be made by the Honorable Trial Court Judge that if you want to enter into defense, then before that, you have to deposit this by way of an interim compensation. Otherwise, what happens that after the trial is over, and if a person feels that I will go to jail, but I will not pay 5 lakhs or 10 lakh compensation, I may be there for a year or 6 months or whatever it may be, or 4 or 5 years. Either there should be a two way. Plea bargaining is there, where also it can be used for that purpose is concerned, because it's a very wide topic. We have talked about the offense relating to human body, but there are offenses where a poor person is deprived of his land by a land sharker or so far as other parts are concerned. And at the end of it, if there is a compensations in lakhs or crores, the persons will go out of it. Or suppose that during the trial, the person expires or whatever happens because of a long pending these things, then what will happen? So according to me, if there can be a provision that at the initial stage, once the charge sheet is filed, the prosecution can make the applications to the Honorable Court to bring to his notice that it is a fit case where the prima facie case of giving compensations beside the trial, and the accused may be directed to deposit that much amount, and then the trial can be begun.
Perfect. Sir, your recommendation is so good that it will make this system to be justice-centered. Sir, I think your recommendation will play a huge role in making the system justice-centric and victim-centric. And your point on not just emphasizing offenses against body, but also those which deprive life and livelihood also is well taken. We will take note of that. I request Professor Kulkarni to go further and suggest.
Madam, can I come in with a very brief intervention?
Please.
Yeah. 2-3 points I would like to submit. One is like calculation of the compensation. Like if you'll see a case, very landmark case, Vikas Yadav case of Delhi High Court, it has given a lot of criteria and parameter how to calculate the victim compensation. So I think that can also be considered while calculating the compensation by the courts. Second is, there may be also a good provision, because if you'll see the Protection of Human Rights Act 1993 and as amended twice, there is a provision for the human rights courts under section 30. And this court of session should be declared as the human rights court. Now, if a procedure is being made, like as Professor Madhav Menon committee has also suggested, that we need 3-4 kind of procedures, not only one criminal procedure code, so that these courts, if they can take off, and then they can also be a big relief for the victims of violation of human rights, because they are the most sufferers, because there is no demarcation presently between the criminal law and the victims of human rights violation, which can be taken up by these courts. Third point is this, that UN Declaration on Victims of a basic principle of justice for victims of crime and abuse of power says 4 components. One, access to justice and fair treatment to the victims. Another, the restitution. So restitution is generally available in the civil as a civil remedy. But like in few cases where economic offenses are there, the chit fund and you see a lot of economic crimes which are committed and the money is siphoned off from the poor people. Like in Sahara case, Supreme Court has also said that the money has to be deposited by Mr. Sahara, then only he can be released on bail. So there is a need that this restitution also, because restitution is one of the aspects beside compensation, to be instituted in deserving criminal cases, so that can also be granted by the court. Third is 357C. If you will see this section, treatment of victims. This section is not, because one-stop centers are being run by the health department, and there is no proper coordination between this. And so far as the paucity of fund is there, if one will analyze the Nirbhaya fund, which is allocated by the Union Home Ministry to various states, this is not properly utilized. So there is not always the paucity of funds, but I think there is also problems in the procedural fault. And finally, as had been said, like the offenders, in one case, the state of Gujarat versus Honorable High Court of Gujarat in 1998, Supreme Court has said that the wages for prisoners should be revised and one portion may be deducted and that may go to that victims of crime. But there is no you see schemes. States have devised various kind of schemes to disperse this fund, but the schemes are not so disseminated to the people, as well as also the victims also don't know that there is any kind of provision. So there is need that we can also, and when I spoke to several jail officers, they said a lot of money has been accumulated in this fund. But one major problem which they are facing is that if the court, while giving the final order for conviction, if can write in the judgment that who is the victim in this crime and the address of the victim, then it would be easier to reach out directly to the victims and the money can be compensated to them through that.
Right, sir. So thank you very much for that wonderful intervention. Professor Shirish, can you move forward, please? We have Advocate Sampath Bulusu's reflection that a procedure can be put in place where a victim satisfaction report and undertaking is taken, and then there needs to be common standards for compensation, because now it is varying from state to state. There must be a common base amount, and this common minimum base amount should be reviewed on fixed intervals. Very good suggestions. So we will put them through. Any other point, Professor Shirish, before we move on to the polling?
Yes, ma'am. Ma'am, the next
this
topic.
is not Shirish, this is Chaitrali now, sorry. Yeah, Chaitrali. We have to be quick because how many more recommendations do we have in discussion? Because all the panelists have finished reflecting.
Yes, ma'am. I'm 12 there. I'll quickly go through it. So, need of extent one-stop center.
No, this has been read by all because the
Yes,
slide was on.
Yes,
it is already clear and everybody responded to it.
Yes, ma'am. Ma'am, there is something called for third gender also. Everybody are looking for third gender also should be given equal treatment. Another effective point is like the victim shall also play effective role on the state of investigation procedure. And as per section 24(8) and 301 of IPC of CRPC mentions that private lawyer participation is ineffective as the lawyer is required to act as a prosecutor's direction. And so this act, many people recommended it that victim want to engage a lawyer can also engage a lawyer, but in this the lawyer play only a role of just looking into the case. The second
here I would like to intervene, Chaitrali
Dr. Shali ma'am, these two are the most important and we have touched the soft nerve here of the system. And Chaitrali is presenting that slide, the second point also. So please intervene, ma'am. Yes.
So as regards section 24(8) now, which is introduced by way of amendment in 2009, I mean, you know, it is said, I mean, this slide, there is a distinction between section 24(8) and 301 of CRPC. 24(8), what it says, that private counsel can, I mean, permit the advocate engaged by victim to participate in proceeding and to assist the prosecution. So Allahabad High Court, UP High Court has, you know, interpreted it in such a way that 301 says that he should assist the public prosecutor, whereas 24(8) says that he should assist the prosecution. So it is quite wider in connotation, and therefore in its judgment in Lokesh Singh versus State of UP, that is 26th August 2013, the Allahabad High Court has said that his right will not only include now only to file the written submissions after the case is over, but throughout prosecution, he can assist, he can make oral submissions also, because he is to assist the prosecution and not only to assist the public prosecutor. So now that role of private counsel is quite widened by this judgment. So we may get some more judgments also like this, which have broadened the scope of section 24(8). because of the slight distinction in the wording used in 24(8) and 301 CRPC. They have also said that simultaneous amendment is not made in 301, but we have to make a harmonious construction, and therefore we have to hold that when 24(8) was introduced, it follows that now the legislature want to give more role to the private counsel, and therefore he can assist the prosecution throughout. So not only written but oral submissions also he can, a larger role is given to him now, and that is really important because of this judgment of Allahabad High Court, and there must be several such judgments also. So that I would like to know, I mean really comment this way that now the role is increase of private lawyers.
Great, ma'am. So this we will take cognizance of this judgment. We will add it to the and your recommendations. I would be very curious to know what a private practitioner like S.K. Jain sir thinks in terms of, I mean, who always defend the accused. I would be very curious to know what their view is, or somebody who has practiced like Mr. Sunil Chauhan, what they think of this giving interest to the victim in the criminal justice system. And this is one of the intentions of our Home Minister rather, that there should be people's interest. I mean, I have seen helping the victims that nobody bothers. It's not their sister, it's not their mother, somebody else's sister, somebody else's mother. So giving the expert support through a lawyer instead of this impersonal state-centric approach to victims' plight, what could be the other ways of making it efficient, effective role in investigation, as we highlighted? And the second point, Chaitrali, could you talk about the second point, which is a pain point again? Yeah. Ms. Chaitrali, yeah.
Yes,
yeah, before Chauhan sir comes in, tell the second point about the lady doctor's presence. And
yes, ma'am. Ma'am, in the section 164 of CRPCA, it has been like, victim undergo lot of humiliation, and in the it is not mentioned examination of lady victim should be examined by a lady doctor and or by a female under supervision of the lady doctor.
Okay, Chauhan sir was coming in. Sir.
Secondary victimization is something which happens to the victim. And first of all, as far as legal assistance to the victim is concerned, for instance, in case of a person who is arrested, we do have a provision in section 41 capital D that he has a right to legal assistance. But we do not have a similar provision, a general provision for all the victims of crime, that from the police station itself, they do have the right to legal assistance. So that is missing. But what we are doing, that in one-stop centers, we are partnering with the one-stop centers, coordinating with the one-stop centers, so that any victim of any lady, any female who is a victim of crime, if she comes to the one-stop center, so her legal needs are taken care of by the Legal Services Authority. This is something which can be, mandated legislatively, that one-stop centers should be coordinated. Some legal assistance should be provided there only. Otherwise, one-stop centers have no meaning. One thing. Now, secondly, as far as examination in the presence of female is concerned, the provision is already there, but still women are not aware of the same, and due to the paucity of doctors also, sometimes it becomes very difficult also. So this is something which need to be tackled at the administrative level by the governments. If we introduce some legislative change also, we need to, instead of legislative change, we need to frame some workable solution for the same.
Perfect, sir. So should we be process oriented and result oriented, or individual oriented is the question, which is one of the core values here when we do this deliberation. So Advocate Sampath was pointing out that there should be I told you already, victim satisfaction report, and this center should be there. And then he also says victim assistance booklet should be kept in all police stations and courts. Maybe this is where law schools could come in. Thank you, sir.
Quickly, Chaitrali, let's wind up this because we
Yes,
are
ma'am.
already running ahead of time.
Yes, ma'am. Ma'am,
Yeah.
there is a need to a need for public spirit participation where victim, if she do not want to approach to the police station to file FIR, she,
Next
on behalf
slide.
of a NGO can take place. Unlike in the POSCO Act, there is a provision. Then victim secondary compensation impact analysis should be there. That is like, many have positive about it. And under section 498A, which has now been a bailable section, earlier it was a non-bailable section. As per the new NCRB data of 2019, it has been observed that 30.9% of cases that has been registered this year is crime based on cruelty by husband and relative. So should this section again be reconstructed into non-bailable, and marital rape should be considered as a separate offense.
So this is a little hornet's nest, the marital rape as well as 498A as far as India is concerned. But the reality of crime shows otherwise, that it is still a serious issue. Always in political discussion, 498A seems to be a biggest pawn compromised. I mean, even the commission where I was a member, they wanted to make it diluted, and we fought tooth and nail in that committee of 10, why our country is so unwilling to look at the reality and look at the provisions. I would request Advocate Latika or Justice Shalini to reflect on this, please.
Ma'am, I would like to say that the 490, the victim compensation, I think is a part of a victim rehabilitation.
Yeah.
But the point is that always every accused who is convicted definitely goes into an appeal. And so long as the appeals are pending, the possibility of recovery of the compensation is not there. So as it is said, the interim compensation should be made a part of the whole trial system, or as S.K. Jain sir said, that when the prosecutor starts his case or explains his case in the beginning, if there is a possibility that the case is very strong and the possibilities of conviction are there, then the compensation aspect, or at least the interim compensation, was something like an acid attack. Or maybe I have seen several burns cases where the women face traumatic situations and medical expenses, there is nobody to pay. So at least for the medical treatment part, interim compensation should be made possible or should be provided to the victim, which will go a long way.
Thank you, ma'am. It should include even psychiatric counseling and things like that.
Yes, definitely. Psychiatric, maybe in the rape case, or the calculation of compensation in a mental trauma is very difficult. How to calculate? How will you calculate the damage to the psyche or damage to the whole psychological position of the woman is very difficult. But at least some compensation in the form of medical.
Not difficult, ma'am. Sorry to intervene. It's not difficult. There are measurements now, and this can be calculated.
It's advanced much more now. Yeah. Thank you, ma'am.
Also, it should be the right of the person to seek to get psychological and psychiatric care. It should be the right. It's not only a charity by the court.
Because there is interdependence of physical and mental trauma as well, isn't it? Yeah. So coming back to polling, we are going ahead with the polling on the themes that we discussed. I think we should wind up here. Thank you, one and all the panelists, as far as this theme of victim compensation was concerned. It has been a very, very elevated, mature discussion. Any word from Justice Shalini ma'am as the final word?
I think compensation concept we have to understand. It is not only to compensate for the loss, injuries suffered by the victim, but it is also to penalize the state for not, doing its duty of maintaining law and order properly. So in the road accident case, we pay the compensation even for no fault liability. So here the victim is the victim of crime and she has suffered. So therefore there has to be the compensation, and on that aspect, we have to really sensitize and create awareness And in the victims, their counsels, I mean, as I already said, that it is their duty also to make the court pass some order. And as regards interim compensation, the Supreme Court has said long back in the judgment of Bodhisattva Gautama that it is you can pay interim compensation and you are required to pay considering the necessity of such compensation. And for restitution, definitely POSCO Act has made lot of provisions, and they can be, transposed or used in the CRPC also. Those rules can be incorporated in CRPC also as regards restitution. So whatever we are doing at present for the victims of sexual offences, the same things if we do for the victims of other offences, maybe domestic violence, cruelty or body offences or economic offences, that will really serve the object of this entire provision as such.
Thank you, ma'am. Dr. Shetty has also suggested that dehumanization is the illness that cops suffer, and there needs to be continuous sensitization of police and lawyers, especially in case of burn cases and rape victims. There is a need for mental health care. Now, this is marking the end of this panel on victim compensation. It's the third panel, and thank you, Professor Chaitrali, for that very organized presentation. We move to the next one, but before that, I would invite the compeer to declare if we are having any privilege of any break or anything like that to break the monotony. So over to Lasya, please.
Thank you, ma'am. And thank you very much to all the panelists for such an excellent discourse on this topic. We will now be, before going on to the next theme, we will be taking a break for 5 minutes. So I request all the panelists to regroup again by 5:55. Thank you very much.
Thank you.
Ashish, I'll have to leave. Can I? आणखीन काय आहे का माझं पुढे हा काय आहे का आहे काय चांगली काय आहे Mr. Karan? It's the last panel. अच्छा तर आम्ही असं करा ना मला फोनवर द्या लिंक हां हां because I'll be on the road.
Yes, let's start. Is everybody there, the panelists?
Welcome back to the experts and the panelists and all the audience members. We will now move on to theme D, our fourth panel for today, which is dealing with the issue of misuse of provisions on withdrawal from prosecution. To join Dr. Shashikala Gorpur ma'am, we have Dr. Ashish Deshpande, Assistant Professor, SLS Pune, to be the co-moderator, And I invite the moderators to commence the panel discussion.
Thank you, Professor Lasya, and thank you, our esteemed panelists as well as audience. It's our pleasure to get back to the proceedings. This part of the proceeding is going to be a relatively shorter one, where Professor Ashish Deshpande, Dr. Ashish Deshpande will be my co-moderator, and the theme is going to be misuse of provisions on withdrawal of prosecution. So over to Professor Ashish Deshpande to present the data from our survey, and then I call upon our esteemed panelists, including Advocate S.K. Jain sir, Mr. Nitin Kundavle Patil, and Advocate Hitesh Jain ji, Dr. D.P. Singh, and Advocate Sampath Pulissu. So, Professor Ashish, to begin.
Good evening, one and all. In this discussion, we have only 3 recommendations. But before that, those recommendations, few seconds, I just want to share the roots of prosecution. If we look at the Code of Criminal Procedure, the prosecution, the part of prosecution is very much close to the offices of the courts. That is part and parcel of the offices of the court. That is number 1. But if we open newspaper, daily basis, we will come to know a few cases that the government has assured that few cases will be withdrawn. We will withdraw these cases, that cases, giving favor to a particular caste or a particular community or any particular region. So this is one of the very, very burning issues so far as the administration of justice is concerned. Because if we look at section 321 of the Code of Criminal Procedure, we will come to know that this is the exclusive prerogative of the public prosecutor or assistant public prosecutor in the case to initiate withdrawal. But practically speaking, politically, that particular section is abused. We don't want to take names of the particular states, but each and every state, somewhere, somehow, assurances are given, that sweet kind of what we can say, statements are being made that we will withdraw the cases and to make particular community or particular people happy. So for that reason, we had scrutinized that particular issue, and we have 3 basic recommendations. Number 1 is the exclusive power of the withdrawal of cases to be given to the specific courts. That is number 1. The another one is there should be role of victims so far as withdrawal of prosecution is concerned. If we look at the damage, if we look at the loss, the real persons, the real what we can say sector in the society, which is what we can say in the negative side, we will come to know that the victims are not being considered. So there should be role given to the victim also. And another one is that is very much crucial, that there should be clear-cut criteria so far as the what kind of cases to be withdrawn and what kind of cases should not be withdrawn at any cost so far as section 321 is concerned. So data is in front of us. So that is something about withdrawal of prosecution. Thank you.
Ma'am, you're muted.
I divert my attention to Advocate S.K. Jain in the light of this. What could be the rationality in making withdrawal to be at the discretion of the executive? Or was it simply irrational? Are we continuing the colonial system? Or are we keeping some gaps so that political powers that be have their say? May I have Advocate S.K. Jain sir speak?
Madam, I think Jain sir is not
the radar.
Yeah.
Okay, then shall I ask Mr. Nitin?
Yeah, ma'am.
Nitin Kundavle Patil, please. Yeah.
Thank you for giving me an opportunity, ma'am. I think Dr. Ashish is having the PhD thesis of this subject itself. So I could see his command over the subject, ma'am. I should congratulate Dr. Ashish for the successful PhD thesis. I went through the thesis yesterday itself. Yeah, ma'am, you rightly said that it's we are just following the colonial model of withdrawal. So I firmly believe that the best practices are always to be followed, whether that to be of Germany, France. I would like to add one more country to this. Austria also has a very good model of prosecution, withdrawal of prosecution. So we should always follow that model of withdrawal of prosecution. Yes, with this, the start by Dr. Ashish was of the somewhat of political nature. I wish to commence with the saying that right to protest is implicit in the right to free speech and assemble. So, if the political activity will be rendered impossible, we will see a role in prevention of withdrawal of the political assemblies. So we have to take that care, that also into consideration. Further, the withdrawal of cases prosecution, I must quote here the two particular divisional benches of Allahabad High Court decisions, one in the case of Agnihotri and second in the case of Ram Naresh Yadav, wherein the court has specifically laid down 4 questions in the first case and 3 questions in the second case. Well, going back to the 2010 National Litigation Policy, I think in the chapter 9 or chapter 10 itself, this particular withdrawal of prosecution directly or indirectly has been mentioned by the in that particular chapter for the review of the cases. So yes, this is a very debatable issue. It was in the news in 2018, wherein I think the states like UP and Haryana have taken tremendous vast decisions of withdrawing of nearly 20 to 20,000 cases. I think in the case of riots of Muzaffarabad, where the chief minister itself was one of the accused. And there were the headings in those years that Yogi rescue Yogi itself. So this is a very debatable issue, I think.
Hello.
Yeah.
So you have brought very good data, Mr. Patil. I was just wondering, there was this withdrawal issue of 498A, and in Karnataka, I had seen it very closely, where prosecutors were not allowed to advise the victim, or finally they had to go to the Home Ministry and get it withdrawn. And in the Home Ministry, the secretary is the one who signs, and invariably these secretaries are ex-IPS. Now, what is the fun in putting withdrawal in the hands of someone who is non-judicial? So I'm very curious about this. I think Advocate Sampath has been through criminal law practice. Any reflections on this, Advocate Sampath?
Thank you very much, madam. Well, I have certain views on this, and I would just take you through all the members of the panel and also the audience. And please bear with me. I may go into little detail. At the outset, with due respect, I would say that withdrawal of prosecution, which is enshrined in section 321 of CRPC, is not a colonial relic. Under the old CRPC, what we had was section 494, which had the title of Effect of Withdrawal from Prosecution. This has been modified in the 1973 code. If I take section 494 of the old CRPC 1898, it says, any public prosecutor may, with the consent of the court, in cases tried by jury before the return of the verdict, or any cases before the judgment is pronounced, withdraw from prosecution of any person, either generally or in respect to one or more offences for which he is tried, upon such withdrawal, the case would have the effect of acquittal or discharge. So this is what was stated in 494 of the old CRPC. Under the old code, it was only on public prosecutors, which meant that this was only with respect to session trials. This was a colonial provision. Section 370, when Section 321 had come onto the statute book in the 1973 code, this has been, enlarged, wherein it was also the public prosecutor as well as the assistant public prosecutor who is in charge of the case with the consent of the court that such withdrawal from prosecution. It's not withdrawal of prosecution, it is withdrawal from prosecution. Both are completely different. Now, if we go to the earliest judgment on this point, and that is on this particular section 321, after it came on the statute book in 1973, which arose in Rajendra Kumar versus State through Special Police Establishment, that is 1980, volume 3, SCC page number 435, the Supreme Court had said, and this was the case that arose out of the Baroda dynamite case, which happened during the emergency, wherein veteran leaders of the opposition, like even George Fernandez, were one of the accused. And what did the Honorable Supreme Court say in this case? It shall be the duty of a public prosecutor to inform the grounds for withdrawal to the court, and it shall be the duty of the court to apprise itself of the reasons which prompt the public prosecutor to withdraw from the prosecution. The court has a responsibility and a stake in the administration of criminal justice, and so has the public prosecutor as in its capacity as Minister of Justice. Both have a duty to protect the administration of criminal justice and against possible abuse or misuse by the executive, and resort to the provisions of Section 321. The independence of the judiciary requires that once the case has traveled to the court and its officers alone should have control over the case and decide what it has to be done in each case. Now, this is where I'll pause for a moment when it comes to Rajendra Kumar's case. The next landmark judgment of a 3-judge bench was Shionandan Paswan versus State of Bihar, 1983, Volume 1, SEC, page 438, which was a 3-judge bench judgment. And what did their lordship say in that by majority? Justice V. Khalid, his lordships have summarized that there can be certain grounds on which the, for 4 grounds which can seek withdrawal from prosecution. 1, lack of prospect of successful prosecution in the light of evidence. 2, implication of persons as a result of political or personal vendetta. 3, inexpediency of the prosecution for reasons of the state or public policy. 4, adverse effect on continuance of prosecution, which will bring the public interest in the light of change situation. Now, these were the 4 grounds which were given in Shionandan Paswan's case. However, one of the things which Professor Ashish, and if I'm not wrong, even Mr. Nitin Kondalwade had, if I pronounced the name right, apologies if I pronounced it wrongly, mentioned about the participation of the victim. Now, 321 is silent on the right of victim or the complainant, which is a fact. We have a somewhat similar provision in CRPC, that is section 169 of CRPC, where the police, where upon investigation find that there is no sufficient evidence and file a closure report before the magistrate. Now, when closure report is filed, section 169 of CRPC makes it mandatory that the notice has to be served on the informant or the original complainant. And only when a protest petition comes up before the court and the court finally decides, and the application for closure of the case by way of a report under section 169 of CRPC is not binding upon the magistrate can reject or accept the report. Now, similarly, even in Shionandan Paswan, in Subhash Chandra versus State Chandigarh Administration, 1980 Supreme Court, Abdul Karim versus State of Kerala, the number of judgments, the right of the victim has been to oppose an application, has been challenge the withdrawal from prosecution, has been recognized by the Supreme Court. Now, what the Supreme Court has so far in all the cases that has come is, once the case has been withdrawn, the challenge has occurred. Let us take Abdul Karim's case from Karnataka. What was the actual reason in that particular case? The then brigand Veerappan had kidnapped a famous film star, and the state wanted to release, because there was demands made by Veerappan that certain accused, the TADA cases which were pending in the special TADA court at Mysore were to be withdrawn, and that was only the charges of TADA which will pave way for their bail. The application that was made before the special designated TADA court at Mysore did not spell out anything of Veerappan or the demands. All it said, public interest, we need to withdraw from it. Now, that in the first session that we spoke about the independence of the prosecutor, even here there has to be independence of the prosecutor alone. The state, even if it dictates, the prosecutor should have the right to refuse to file such an application. And when can that be? When the prosecution directorate is strengthened and made fully independent. Now, coming back to the part of the victim's role, what I would like to say is, the victim, since 321 is silent about it, now here victim or complainant, we'll encounter certain practical problems. What are those practical problems? Take a case of rioting and political vandalism. Who is the complainant in those cases? It's necessarily the sub-inspector or the inspector of the police station, or the sub-divisional police officer who is the rank of the deputy superintendent of police, who would be the complainant in those cases. So if a notice goes to them and the state wants the PP to withdraw the case, and PP is also acting on it, justice would not be served. Therefore, 321 has to be amended in such a fashion wherein a notice should go to the victim. There should also be a public notice that should be published in the newspapers, wherein people who would act out of public interest may come and oppose, and only then withdrawal from prosecution should be made. This is the first step which I would suggest as a change for section 321 of CRPC. Thank you very much.
Absolutely. This is what feminist groups argued in 498A, and some states had adopted. But they had a boomeranging effect because they were again going from frying pan to the fire when you had this police officers coming in. Again, these need to be reviewed properly so that the power is once shifted but again taken out, you know. So let's go to...
Madam, there's one more thing which I would just, sorry to interrupt you.
Yeah.
The other factor happens to be section 320 of CRPC, just one provision before 321, talks about compoundable offenses. Now, this particular table which has been there are two categories. One where the cases can be compounded without permission of court and with permission of court. If this table has remained static from quite long. If suppose compounding of offenses is nothing but a compromise in the case where the parties would definitely come in. So what happens is that A, it would discourage trials where the witnesses turn hostile because there has been a settlement that has happened, the case could not be compounded, making the trials farce. So 320, the table can be enhanced, we can have more of entries. Second thing is, what I meant to say was that would also do away with 321 being misused. I can give you an example of, in one such case where the victim was not made a party and, victim did not know that the case was withdrawn, got to know about it later, challenged the matter before the High Court. The revision was pending for 3 years. In the meantime, the accused himself died. So the case should be abated. So if the victim's participation comes at the first instance, we can definitely have a faster relief when it comes to 321, whether 321 could be negated or it could be allowed.
Yes,
thank you.
Agreed. Thank you. Thank you for that valuable information. Now let's ask Dr. D.P. Singh, who is a sociologist and researcher. He's an expert researcher. Sir, we would like to know about your views in this context.
Okay, madam. Actually, I'm not from the background of this your legal this one, but what my personal experience and all these are there, and something like previously you said about the role of politician. No, I think the role of politician is very clear. The moment they come in the picture, they spoil the whole case. You have seen this recently, 2-3 cases: Balia case, Hathras case, Bombay case. And from last, this media also now has become very active. They give the judgment itself. So even I think that in the withdrawal, lot of people there play their own role. No, money has to be spent, and the money goes. That is what to me understood that this is what called withdrawal. When people get fed up, they say, "यार अगली जिंदगी में कुछ ये जिंदगी तो बर्बाद हो गई, अगली जिंदगी तो बच्चों की बचे." Then they withdraw the case. So what is the real truth? It never comes out. Okay, so that what I see from that like we don't know whether there is any law or not. Like a politician can scold anyone, but we cannot scold politician. I think there is something like that. No, MLA and all this one, you cannot criticize their role. So I think somewhere in the law, everyone should be accountable. You are not above the anyone. Don't tell someone very bad language or anything like you have seen yesterday what, in MP one CM said something to a lady. Nothing will happen. Just it is a political game or what is called 2020 fixing. So I think that, some kind of, when the case is runs for a longer time, there just should have a power to say that whether now you cannot be right. They have spent their time. And finally you settle it. 1 lakh मेरे को दे दो, 1 lakh वकील को दे दो, हो गया बराबर. Okay, man.
Right, sir. Thank you.
I gave my personal. I told in the beginning itself. I don't know that what is 21 and this law.
Right. Right.
Yeah. Okay.
We understand. So here there is Dr. Shetty coming in saying that can we have a scientific protocol to decide when a case can be withdrawn? A kind of assessment sheet and also an assessment sheet or checklist to make the withdrawal more sacrosanct and justice oriented and victim participation in the withdrawal.
Thank you, Doctor. And Dr. Ashish, is there any other point that we need to add, because we wanted this to be a shorter session? Is there any panelists that we have left out? I'm not sure if Mr. Hitesh Jain is still on the panel or has he left?
Sorry about that. I didn't hear anything.
Okay, we have our very esteemed Defense Counsel, Satish Manshinde, sir. Welcome, sir. We missed you in the first session. We know how busy.
No, madam, I'm sorry. I was engaged in some other proceedings.
Yes, sir, we could understand.
I could not join you. And since, this is a virtual time these days,
yeah,
there was a hearing going on in the High Court. So
right.
I was involved in the High Court
Right.
proceedings.
So it's our loss to miss you in the beginning. Anyway, it's great that you have come in at the right time when we are closing on a topic related to prosecution. So do you have any observation to make, even for the themes which you might have prepared but missed, like what we did earlier in terms of polling on improving the conviction rate, on providing witness protection, on advancing victim protection and rehabilitation, and the current theme of misuse of provision on withdrawal? Any deliberation from your part?
Well, I can only express my practical experience that I've had in dealing with criminal law for the last 37 years. My experience on the whole is very dismal, in the sense that right from the inception, attempts are made by various individuals and entities to subvert the prosecution, because the truth rarely comes before the court. One of the reasons for all this is because the people are totally disinterested in the administration of justice.
Yes.
More so because witnesses who have ocular evidence to depose before the court through the police, most of them are not contacted properly by the prosecution. And therefore, we lose the best evidence. And by the time the evidence is recorded, it's a delayed, recording of the evidence. So you miss out the best portion of the evidence and the best memory of the witness. Secondly, I'm sure all of you have debated on this number of times, and even today, that there is total corruption in the police department at various levels. I won't say it is 100%, but it's on the rampant increase now. Therefore, there has to be a specialized investigating agency to investigate offences, and it should not be left to the constabulary and law and order enforcing agencies. There must be a specialized agency to investigate these cases, like we have the CBI, we have the CID, we have the Detection of Crime Branch, Anti-Corruption Bureau, and all these. Apart from all that, most of the evidence that is recorded these days, no attempts are being made to record most of them under 164 of the CRPC. Particularly the eyewitnesses. The statements should and ought to be recorded under 164 of the CRPC, because we can use all technical methods of recording the evidence, apart from oral evidence that is recorded by the magistrate, in such a manner that the witnesses who come before the magistrate and record the statements under 164 stand by it, so that we don't have to prove that evidence through some other witnesses in a court of law. Subsequently, what has to be also done is that Namita, just come in. What we must do is the witness protection program, which is now before the Supreme Court. The Honorable Supreme Court has time and again called upon the central government as well as the various state governments to come up with a policy to deal with this witness protection program. And I'm sure that all of you are dealing with this day in and day out and following what is happening in the Supreme Court. Unfortunately, majority of the states have not come up with a policy to frame proper guidelines for witness protection. Now, every political party which comes to power and makes statements, they talk about providing the best judicial system and the best prosecuting system. But the moment they leave the government, they are committing crimes themselves. Therefore, the Supreme Court should not wait for the parliament or the state legislature to formulate a witness protection program. Under Article 142, the Supreme Court should lay its own guidelines, like in the corruption cases against politicians, to see that this has a salutary effect on the judicial system. Fourthly and importantly, there is rampant corruption in the judiciary. Though there are a few black sheep, the entire judiciary is getting a blame because of a few black sheep. But I see that, it is on the increase, obviously because of the salary structure and because of financial burden on the judicial officers and easy access to money, and there is no proper watch on these gentlemen. So therefore, that also needs to be plugged. You will see that by the time the case comes up to the High Court or the Supreme Court, the prosecution has been so watered down, and even the delay that is taking place because of judicial system that we have, it is suffering, and ultimately the victims who come before the court number of times are the losers. Now, question of the first informant or the victim's family coming before the court to assist in the prosecution should be encouraged. It is not necessary that they must have a right of audience, but they should have a right in selecting the best prosecutor so that they can guide not only the prosecutor, but help the administration of justice to bring powerful and wealthy accused to book. Apart from all this, what needs to be also taken into consideration is that the number of attempts are being made to curb the victim's rights in the court of law. So the judiciary should come up with some formulae where, apart from seeing that they are present in the court, they should be given adequate notice of the hearings that takes place. Now, electronic age has come into picture. It is not difficult to contact the victim's family and inform them that this is the proceeding that is going to take place. So with these few suggestions of mine, which are practical in nature, and particularly all the service of summons, notices, everything is accepted electronically in all the courts these days, all over the world. So I'm sure that if electronic methods are used, not only at the time of investigation, trial, and in appeal courts. For example, many time it was being contended by a lot of us that just because the Supreme Court is located in Delhi, the poor and downtrodden people who are victims of these crimes, they don't get a chance to approach the apex court and make their submissions. Since the pandemic, the method in which the judiciary is functioning is through virtual courts. So, apart from the day-to-day hearing that may take place after the pandemic is over, my suggestion is that these virtual courts should be in existence. At least half the court should sit in virtual hearings and conduct hearings and hear lawyers and parties from all over the country, so that the amount of money that is being spent on litigation, on filing proceedings, on engaging lawyers, on traveling to Delhi and making presentation before the Supreme Court would be curtailed, and that can be done by increasing the number of judges. If the central government, which has been tasked with setting up courts all over the country, is of considered view that it is not going to take such large amounts of money to set up virtual courts, this method of conducting virtual hearings of various appeals and civil cases should be taken up by the central government with the help of the Supreme Court. And a large number of judges should be appointed, because you don't need a full-fledged courtroom to conduct a virtual court hearing. The judges can conduct the virtual court hearings from their chambers. They wouldn't need a large amount of staff. They wouldn't need the entire pleadings to be filed in physical form. It can be found in electronic form, and therefore it will ease the burden not only on the judiciary but on the central government, which is tasked with providing funds for these courts to be set up all over the country. If
Right,
the
sir.
Supreme Court
Yeah.
takes up this issue, that apart from conducting personal hearings that it is likely to conduct after the pandemic is over, it should also set up a large number of courts to conduct virtual hearings so that people from all walks of life will have access to justice. So these are the few suggestions, particularly in view of the pandemic. All the courts are functioning. All the courts are conducting virtual hearings. In fact, remand proceedings, even on the first occasion, in a large number of cases in Mumbai, are taking place on virtual hearings. So the person is produced virtually even for the first time. The remand proceedings are taken up by the magistrate on the virtual courtroom. After the proceedings are over, if he is remanded to police custody, he is sent to police custody. If he is sent to judicial custody, forthwith he is sent to the jail authorities, and therefore the criminal law sets in motion. Similarly, appeals.
Yeah,
And
sir, we will take up these points as we move on, because what we are doing is we are doing a thematic kind of splitting up of themes. So true to your spirit of being kind of what we can say mentee of Advocate Ram Jethmalani, who used to say that there should be 4 benches of the Supreme Court. This was pre-COVID.
Yeah.
And your suggestion is so good that it will definitely protect the right of access to justice. We need to wind up with this theme, sir, and then we are moving on to a couple of other themes where we will request you to again continue the
yes, thank you.
Yeah, thank you very much, sir. Very, very valuable insights have come from you as a long-term and
Though my senior suggested 4 Supreme Court benches all over, with the virtual court hearings, you can have more benches all over the country.
Yeah, like one of my professors suggested there should be a writ power in the local courts. It comes to that effect. Supreme Court comes to the doorstep or to the office of the lawyer or to the residence of the...
It may not necessarily be physical hearing, it could be virtual hearing.
That's right. Virtually it will travel everywhere. Yes, sir. Thank you. So thank you, Professor Ashish, for contributing so richly. We move to the next theme, which is the core theme for us in terms of human rights protection, which is issues with current prison system. I think this is one area which is not just prison-centric, but prisoner-centric or detainee-centric, where we have got under trials, large percentage of under trials, as our news reports and analysis reveal, crowding the prisons, and more than 70% almost, and our prisons being overcrowded with 1.6 occupancy, sometimes maybe 3 times. So with that in the background, I request the computer to set the stage for the next session, please.
Thank you very much, ma'am. Thank you to all the panelists of the previous panel for your detailed analysis of the topics that we have been bringing up. We've also received the polling results, which have been displayed in the course of the discussion itself. I would like to remind all the audience members that the polling link would be posted on the chat box simultaneously as the panel is progressing in the interest of time. So we will now be moving forward to the next panel, which is resolving issues with the current prison system. And to join Dr. Shashikala Gurpur to moderate this session is Advocate Sangramjit Shravan sir. So I would like to invite the moderators to begin the panel discussion on this issue.
Thank you, Professor Lasya, and welcome Advocate Sangramjit, my moderator here. We are looking at resolving issues with the current prison system, where we would like to, as I mentioned earlier, we would like to look at the the convicts as well as under trials. And I would like to invite the attention of all of you to what was mentioned in Professor Ukay's book, the Law Commission's 268th report of 2017, which talks about narrowing or modifying the approach under 436A on the denial of bail. They also suggested that there should be a computer-based accused or criminal tracking network for habitual offenders, and the tripod approach in terms of refusal of bail, So with that in the background, I call upon Advocate Samramjit Chauhan to present our stakeholder feedback-based empirical evidences. Over to you.
Good evening, everyone. Due to time restraint, I will keep it short. The existence of the orderly society in India mainly depends upon the sound and efficient functioning of criminal justice system. In order to bring peace and harmony in the society, criminal justice system plays an important role, and maximum sense of security is being provided in the society. Prison plays a very important and vital role in the criminal justice system. Hence, proper administration and governance of the prisons in India is very essential in order to put an end to the increasing crime in the country. Now, after a detailed survey, we found out the main problems faced by the prisoners in India are firstly, overcrowding of the prisons by prisoners. These prisoners mainly include the first-time offenders and the hardened criminals. Now, the main and important reason is to separate hardened criminals from the first-time offenders, as it mainly develops, if they're kept together, it develops a sense of criminal mind, and hence it could be harmful to the society when these first-time offenders are being bailed out or being acquitted again and they're back free to the society. So rehabilitation and reformative measures play an important and vital role and is very important and very useful in order to proper governing of this entire prison system. Now, secondly, there are a large number of under trial prisoners which are languishing in the prison for a very long time, and offenses committed by them are very the punishment for them is like for 2 to 3 years, but due to non-availability of sureties, they are being languishing in the prison. So this is the main and important concern. Trial district lower courts are already overburdened, making it impossible for them to expedite disposal of trial. Lack of awareness among accused relating to the rights is a main and important concern. Difficulty in furnishing surety due to poverty, lack of legal knowledge is also an important issue addressed over here. So after the recommendations which are being stated over here, after a detailed survey which has been made by our esteemed judges, lawyers, panel members, taking into consideration each and every aspect of the persons in the legal field. There is a need to establish court in the jail for the bail and other matters, or in short, fast-track courts, which are necessary to be established near the court. So it would be easy, and also it would reduce the pressure over the police machineries in order to bring the hardened criminals or the first-time offenders to the court of law, because mainly time lapses in that, and due to main hearing also of the cases, the accused is not being brought to the court. Hence, there is a delay in procedure in the trial of the cases. Second, it's need to reduce the conditions of the bail. This is again very important thing. Poor people may be released on bonds. Judiciary should act very proactively on this issue. Need to create awareness of rights, including right to bail, is also an important factor. Need to better implementation and provisions for free legal aid, has been discussed earlier in the prior sessions, is also an important thing. Now, moving on to the second issue, LGBT is also a very important and a new factor coming into consideration. Now, in Indian prisons, we don't have specific provisions for them. So it's very necessary in order to bring them and to construct a proper system. A special board should be established. Need to develop infrastructure, including video conferencing, is also a very important factor. Mental health issues is a very prior and important concern which need to be discussed in a priority basis, because inability to meet family members develop a sense of frustration among the prisoners, resulting in different issues. Also, now we should move on to the next slide regarding the modern manual 2016. The main problems here are lack of manual on rehabilitation. The ideas don't speak on this purpose. Inadequacy of prison staff is also an important factor, and again, the mental issues. So the recommendations which have been stated here is manual experts in rehabilitation shall be appointed. Mainly medical help should be taken. Appointing of certain psychiatrists should be there. Sessions should be conducted regarding the hardened criminals in order to develop a sense of criminal mind should be developed, and should not be developed in a larger sense, because When these prisoners are released back to the society, it may create a harmful effect on the society. Facilities of the children, whenever there is nobody to take care of the children, must also be taken into consideration. So I rest on to the other panel members to discuss the further ideas.
Yeah.
Thank you.
So thank you, Advocate Sangramji. Sangram is also having his LLM thesis on prisoners' rights guided by Dr. Rupal. I invite our expert panelists to respond to the issues that we have raised. We have captured them very quickly, although there is elaborate kind of responses which have come. I have the privilege of having a criminologist like Professor Arvind Tiwari here. So, sir, would you like to come in and give your expert opinion on this? Sir, you have to unmute yourself, I think. Yeah.
Sorry about that. I didn't hear anything.
Am I audible now?
Yes, sir. Please.
Okay. Yeah. Sorry. Now, this is, as Professor Gurpur has also said, this is a very important but neglected theme in the whole criminal justice system. Now, as has been shown by our faculty colleague, that what is the situation in the prisons. Now, majority of the prisoners are under trial prisoners. Let me tell you, prisons are in the least priority of the government, public, as well as within the criminal justice system. Now, who are in the prisons? Therefore, there is no priority for that. 93% around, more than 90% offenders in our country, those who are in the jail, either under trial or the convicted, are the people, those who are not the hardened criminals. Because recidivism rate in our country is around 7%. So it is very less in the world. Now, who are not behind the bars? The mafias, the economic offenders, the organized offenders, development-induced offenders, and all those kind of white-collar criminals, because our legal system is such that they are taking advantage of that. Therefore, they do not, or they hardly come in the clutches of the law. Now, I'll come to the problems, as has been highlighted by in the presentation. What I would like to submit, that section 53 of IPC should be amended, and the provision for two things should be done. Three things. One, community service. Andhra Pradesh Community Service Offenders Act 2013 is also there, which is being implemented in Andhra Pradesh for petty offenses. So those who have committed like pickpocketers and petty offenders, those who have nothing to do in the prison, then unnecessarily they are being sent and their rights are being deprived. So there is a need that the community service should be included as part of one of the sentences, and one act is already there which can be studied. Second is regarding the provision. Provision of Offenders Act 1958 plus provision in the CRPC is not optimally used by the judiciary, unfortunately. This is also another dimension. The people, those who can be let off after the conviction under the supervision of probation officers, can be go to the community and cannot be sent to the jail. So we can little bit decongest the prisons. Also regarding community service, there is a judgment of state through PS Lodhi Colony versus Sanjeev Nanda, which is the BMW case, very famous case, BMW case in Supreme Court of India. In that case also, 2 years community service was ordered by the Supreme Court of India to Sanjeev Nanda. So there is a need first to reconsider the classification and also the type of sentences to be provided. Restitution also, I would like to say, like in economic offenses, organized offenses, white collar offenses, because victim, this is also covering the victim aspect, that victim will not be happy only if one economic offender put behind the bars. The money which is siphoned away by the offender, and even if he is hanged, what the victim is getting. So there is a need that the restitution provision in such kind of offenses in which the offenders are amassing a lot of money, that can also be made as part of the sentence. Now,
thank you, sir.
I will come, just a minute, 2 minutes more.
Yeah.
I'll come specific area wise, like under trial, as has been said about the bail 436 and 436A. Then also for the convicted prisoners like open prison. The Supreme Court now in re-inhuman condition in 1382 prisons has given several orders regarding, so we can divert some of the convicted prison population to the open jail. If you'll see the data in Maharashtra or rest of the India, the open prison, there is no overcrowding in open prisons. Rather, the more strength is there, sanction strength, but the less number of prisoners are there. So there is a need to divert the under trial population through bail, through community service, effective implementation of Provision of Offenders Act, as well as the convicted prisoners population to open jail, and also liberalize parole schemes, so that we can decongest the prison and we can humanize the prisons. Because as has been said, mental health, and there are several areas, I'll come in little later. But these are the major things which I think we can consider. Thank you.
Thank you, sir. Now, from the point of view of criminal justice system, some of the reforms which have been there in case of prisons, how the courts have overseen, or what is the experience as a judge, Madam Shalini, if you could come in and respond. Ma'am, it's muted. I think you'll have to unmute yourself. Yeah, please.
Actually, bail is the rule and jail is the exception. That we are saying since long. But despite that, we find that so many under trial prisoners are there. The reason, one of the reason, maybe the prisons are overcrowded, and as Chauhan has rightly said, that first offenders and repeated or habitual offenders, they should be separated, hardened offenders, so that we have at least to some extent a limited law and order problem. Secondly, under trial prisoners, how to reduce it? We have introduced the system of plea bargaining. I mean, there is a separate chapter in CRPC, but that provisions are not used at all. I mean, if the accused really feels that he is guilty and he is having the assurance that some lesser punishment will be imposed, then those as regards plea bargaining, there should be more enlightenment, and as regards bail also, we should have more liberal approach. Secondly, what we find is, it is mostly the use of arrest powers by the police also. We have already tried to reduce it by amending section 41 of CRPC. But then nowadays, serious offenses are also increasing to such an extent that under trial prisoners mostly consist of those offenders to whom it is difficult to release on bail. So far as minor offences are concerned, we find that magistrates are really liberally releasing them on bail, or after undergoing half of the punishment also, they are released on as of right on bail. But the under trial prisoners mostly consist of those offences like rape, murder, dacoity, or some serious offences where it may be difficult to grant the bail, and that may be the reason. And therefore, the only solution we can say is to increase the number of prisons. Then we have to improve the system in the prisons, and in that respect, to make it humanized, we should have an independent committee to inspect the prisons from time to time. We used to have such committee of principal district judge, then district collector, and some important functionaries in the district who are supposed to visit the prisons every month or quarterly and submit the report and ensure that whatever deficiencies were found, they should be removed. They show compliance of that report also. They have to overlook and monitor that system. And we used to, when I was a district judge, we used to do that. But now, district judges and district judiciary is also so much overburdened that it may not be possible for them to pay one day for the visit. So these are all the various issues from practical point of view. But even then, we can insist on these measures, so that in independent committee also, if not a district judge who is, sometimes they may be busy, may not be possible due to preoccupation with judicial work, some independent committee should visit and monitor the conditions in the prison. That is what I really feel that it should be done.
Thank you, ma'am. Now, on the reformist side, instead of the punitive side, how the prisons could look at mental health and rehabilitation. Dr. Shetty, could you come in and share your interventionist experiences, please, quickly?
I worked in the Thana jail for some time with the Gandhians.
And there are 3 sections there which are very important. One is the habitual offenders. Their main preoccupation is inform the mother so that they get bail. Find a way to inform the parents, friends to get a bail. The second section was the first time offenders. They don't know what's happened to them. It's just a wall which is them. And the third were for gangsters. They were exercising. They had milk, they had badam, they had pista and everything. Now, what is very important is I completely agree with the view that hardcore psychopaths should not be in contact with the first-time offenders. And that is something which is absolutely essential. That's number one. Number two, which is very important, is there has been efforts in jails across the country with Vipassana, yoga, and so many other things. We need to actually humanize the jail through methods by which there could be some iota of reform happening to them when they are out. And see that the stay in the jail is not very comforting, but at the same time, it has a reformatory. And the last thing which is very important, ma'am, is that high-risk cases who are mentally ill, there have been patients of postpartum depression serving long sentences or even awaiting a trial. These should be screened and they should be provided care and treatment with the nearest hospital available. That I think is very, very, very important. Thank you, ma'am.
Thank you, sir. Thank you, Dr. Shetty. That's a very valuable insight. And I think such interventions, whether jail manual is providing or should we amend jail manual, we will look into that when we send our recommendation. Next, I request Mr. Sunil Chavan, sir. He is rather judge. Sir, quickly, your take on how legal aid services could be helping in alleviating this pressure on the prison, please.
Yeah, first of all, I'll come to the source of. First of all, let me clarify one thing. As it was mentioned in the presentation, that there are 69% of under trial prisoners. That percentage comes when you take percentage out of the total prisoners. But if you see the number of cases pending in the courts, criminal cases, they are 2.33 crore. So if you take out the percentage of under trials from that population, it comes out to be 1.4%, meaning thereby 1.4% of the people accused are in prisons, and 98% of the accused are on bail. That is one fact which I wanted to clarify. Now, coming to section 41A. In 2009, this section was introduced, and this section has introduced pre-arrest stay. That is, a person can be called to the police station as a suspect. But as far as the implementation of this section is concerned, that's very poor. And people, the police, they do arrest, they do make unnecessary arrests. Now, if you see section 41 capital D, when a person is arrested, he has right to legal assistance. But if you find such section for a suspect, you won't find such section in CRPC. You have to go back to Nandini Shatapati, where it is mentioned near custodial interrogation, right? So, as the rights of the arrested persons have been mentioned in CRPC, so there is a need to mention the rights of the suspects, so that, for instance, it can be mentioned that he should be informed of the accusation against him, and a suspect has a right to legal assistance. Now, what legal services authorities have done in this regard? Last year, they have formulated a protocol for providing legal assistance at the police station and at remand stage. So in police stations, what we are doing, we are providing legal assistance to the suspects who are called to the police station, and even to the persons who are arrested but not produced before the police station, before the magistrate. This is one thing. So first suggestion is this, that the rights of the suspect should be mentioned, and it should be mandated. Police officials, police officials should be mandated to follow the said rights. Second thing is that there are victimless crimes where there are no victims. For instance, in Excise Act, in Shop Act. So these victimless crimes should be decriminalized. There is no need to arrest a person and produce him before the magistrate just for the sake of, ultimately fine is the main thing which is required in such offenses. Third is that in offenses punishable up to 2 years, arrest should be clearly banned. And for offenses from 3 to 5 years, the arrest should be made with the permission of the magistrate. Otherwise, the unnecessary arrest will not stop. Third is the fourth point, which I would like to make, is a condition of local surety. Many courts, they do pass the orders for furnishing of local surety. If a person belongs to Delhi and he goes to Tamil Nadu for some work, and he's driving a car and meets and some accident occurs, how he will procure a local surety? Motiram versus state of Madhya Pradesh, that was passed in that judgment was passed in 1978, but some sort of other workable solution is to be should be introduced in the legislative mandate itself as far as local surety is concerned, because this is also one of the reasons that many persons, despite of getting bails, they are in the jails. Third is in someone's case, summons case pertain to the less offenses of less gravity. So when notice of acquisition is framed, there is no accused cannot be discharged as is done in the warrant case. So normally, why this has been done for the reason so that the trial does not take much time. Only the gist of the evidence is recorded. But practically what happens, that warrant cases and summon cases, the trial goes in the same way. Long evidences, depositions are recorded. So
right. So, yeah, if you could quickly wind up the next few points that you may have, because
just one point. In the summon cases, I think that discharge provision should be introduced, and in case of strong filtration process that has already been discussed earlier, alternate punishment also has been discussed. Thank you very much.
Thank you, sir. Advocate Sampath, would you like to make a quick point here? Any point which is not covered by any of the panelists and our data?
Yes, ma'am. Thank you. In fact, just taking the continuation from what the last speaker, Sri Chauhan Sahab, has just mentioned, as far as summons cases is concerned, section 258 of CRPC, which is power to stop certain proceedings, which can be done by a magistrate of first class or chief judicial magistrate, is also one more method where the trial is, pending for so long. The courts can liberally, adopt or resort to section 258 of CRPC, 258, which has an effect of discharge. So this can also help in reducing the burden on the prisons. Apart from this, we should also not forget, we were talking a lot on under trial prisoners and jails. There's also something to do with convicts. Convicts in jail are under the prison manual entitled to furlough leave, parole, and this is something which we have seen as in various examples in the recent past. Certain VIP prisoners or certain prisoners do get parole or furlough leave quite easily, whereas there are many prisoners who, despite of having genuine reasons like death in the immediate members of the family, father, etc., where the person has to go and perform his final rites, does not get parole. So there should be some mechanism where the parole or furlough leave should not be just left to the discretion of the jail superintendent or to IG prisons, but there should be some mechanism of some administrative adjudication for grant of these things, because most of these things again end up in the High Court by way of writ petitions. So this is what I would say on one was on summons cases, other one with respect to convicts.
Wonderful. So, so we have captured some of the unique amendments or recommendations which could go. I thank all the learned panelists for their wonderful wisdom and experience, and Dr. Shetty has again put it out how we could humanize the jail by segregating the chronic psychopaths with first-time criminals, which has a long implication. Now, I know that our team is parallelly running the polls with non-panelists, non-experts and audiences, and some of them may be partially experts and academics as well. I request the computer to take over for the next theme, please. Thank you all.
Thank you so much, ma'am. Thank you for the expert experts and panelists for your expert deliberations on the very pertinent questions with respect to the current prison system in India. Before we move on to the next panel, we can take a 3-minute break, a short break, during which time the poll results will also be displayed in this on the screen.
Thank you. So all the panelists, please take this break. You could grab a cup of coffee or take a short walk and come back. Thank you.
Excuse me, madam.
Hello,
sir. If I can help you.
Madam, I have to leave. I have to go for a meeting outside my office.
Oh, sir, now it is cybercrime. After that, we are going on NDPS. So how much time do you have? You have to leave right away or?
No. Since you already risen from the meeting.
No, we didn't rise. We gave a small break because, sir, they have been sitting.
If you can take up NDPS now, it will be more advantageous.
Okay, we'll do that, sir. We'll do that. Lasya.
I'm having coffee.
And Dr. Rupal.
Yes, ma'am.
Could we, I was thinking of rearranging it anyway because I know that sir had come correctly on his slot, you know, busy person. So we will rearrange the NDPS.
Sure.
Yeah. Thank you. Sir, just 2 more minutes and we'll be there. Yeah.
Okay.
Yeah. Are we back? Shall we resume?
Yes, ma'am, sure.
Yeah. Yeah, please.
So welcome back to all the panelists and moderators. Now we will be going into discussion of the theme G, which is a discussion on the Narcotic Drugs and Psychotropic Substances Act of 1985. And to moderate this session, we have Dr. Shashikala Gurpa ma'am. And again, I will be calling upon Professor Shirish Kulkarni to join Shashikala Gurpa ma'am in moderating this session. So I would now invite the moderators to begin and commence the panel discussion.
Thank you. Thank you, Professor Lasya. This legislation has received a lot of public attention, and we are very fortunate to have the lawyer who is in the center of such attention as well, Advocate Satish Manshinde sir. And we have our Honorable former Justice, Madam Shalini Phansalkar, among others, and we have the healer, Dr. Harish Shetty. Aside from that, criminologist, Dr. Arvind Tiwari, Dr. S.C. Raina sir, and Bhanu Pratap Barge sir. So I request my co-moderator to present our data, which we have collected from the stakeholders.
Yes, ma'am.
Yeah.
Thank you very much, ma'am. On behalf of Aditi, ma'am, she has legitimately provided everything systematically on her behalf. Because of some reason, she cannot come online. Therefore, I'm doing. Thank you, ma'am. Quickly taking inputs from the stakeholders, and as ma'am has already mentioned, what is going on with the NDPS recently because of the Riya Chakrabarti's issue and the Bollywood thing in that. We realize that the stakeholders are also very keen in order to really amend the law. And what we found from taking inputs from the stakeholders that as far as the law is concerned, that to really tone down the technicalities in the language in this highly technical legislation, they also gave the input to reclassify the substances mentioned in the provisions of the act. At the same time, they realized that medicinal drugs has not been also taken into consideration because that has led to the misuse of medicinal drugs. So that this is one of the things the stakeholders went. On this basis, I request the panelists, including Satish Manshinde sir, who has closely, taken up the issue of Riya Chakrabarti and has also assisted in terms of understanding the legislation. Over to the panelists.
Yeah, what I mean to say is that the stigmatization as one thing and incarceration vis-a-vis the rehabilitation. And then there has been a lot of movement across the world on legalizing certain drugs, especially the use of cannabis oil in cancer treatment, etc. Are we a little archaic in terms of scientific development? How do we need to revamp this legislation, if at all, while not harming this United Nations movement towards transnational, UNTOC legislation, drugs and crime cartelization? So over to Advocate Satish Manshinde's considered views, sir.
Well, the Narcotic Substances Act, NDPS, was first framed in 1985, where all the offences were punishable with a minimum of 5 years imprisonment. Because of the rampant misuse and the hardship faced by various people, the law was amended in 2001. Prior to that, the United Nations, which had taken up the issue of narcotic substances being rampantly trafficked illegally all over the world, had a convention in 1988 where India was a prime mover because narcotic substances were coming into India from all across the world, particularly its neighboring borders, because of the porous border that we have. And it was very easy to smuggle narcotics from Afghanistan and Pakistan through the Indian borders, as well as through Burma and other areas like Bangladesh. So the United Nations requested the member countries to frame accordingly laws in their own countries. And therefore, India amended the Narcotic Substances Act in 1989 to include illicit trafficking and all other forms of either storing selling, distribution, cultivation, providing shelter, screening offenders. So they were all made punishable with harsher punishments. Where the minimum punishment was about 10 years, which could lead up to 20 years. Subsequently, the parliament found that the law was flagrantly misused, particularly because of the bail provisions, which were very stringent. And a large number of people were languishing in custody without trials. And in many of the offenses, for example, if they were caught with small quantities or for personal consumption, they used to spend more than 5 years in custody pending trial, by which the entire judicial system and the trial system in the country was frustrated because they used to complete their sentence pending trial as under trials. So therefore, the Indian Parliament took up this issue in 2001, 2002 and amended the Narcotic Substances Act in order to define what is a small quantity and what is a commercial quantity, and the quantity in between, neither small or neither commercial, but what would be the punishment. So, for example, marijuana, cannabis, you had a definition of small quantity in the nature of 1 kilo, whereas in other forms of drugs like cocaine and hashish and others, various other quantities were described to make it a small quantity, only in order to see that people who are in possession for the sake of consumption, for personal consumption, and those who are addicts are not punished severely as compared to the people who are trafficking in drugs. Therefore, the law was amended. The punishment was brought down to 1 year maximum for small quantities, 10 years for commercial quantities, and if it is a repeat offender, it is now 20 years. And if a person is found in possession of drugs or found committing any offences, particularly under section 19, 24, 27A, and in relation to commercial quantities, and if he is already a convicted offender, death could be imposed under section 31A of the NDPS Act. So the Bombay High Court, which took up a matter in relation to the death penalty being carried out under section 31A, ruled that not only has a person to be convicted for a commercial quantity in respect of section 19, 24 and 27A, but even on the second occasion, if he is found to be violating section 19, 24, 27A in relation to commercial quantities, only then death punishment could be imposed. So, stringent law which was being misused by awarding death punishment even to people who were caught with small quantities had some breather. Now it has come to light that a large number of people are being released on bail because the general principles of law, according to the CRPC, is that if a punishment is punishable for less than 3 years, it is bailable. And if a person is arrested at the very inception and has been told that he is punishable for an offense up to 3 years, then the person ought to be granted bail at the very first instance. Now, the Bombay High Court in Riya Chakravarti's case has held that all offences are non-bailable, relying upon Baldev Singh's judgment of 1999, which was passed much prior to the amendment of the NDPS Act, due to which now there would be some hardship faced by a large number of people who are arrested for consumption and who are arrested and produced before a magistrate. They would not be entitled to bail as a matter of right, but the magistrate has to use his discretion to find out if he is entitled to bail. Therefore, this impediment of section of the judgment of the Supreme Court according to me, should be reviewed by the Supreme Court, because the Constitution bench in Baldev Singh's case in 1999 passed that law because of the prevailing law that time and the conditions that time. The amendment of Section 2000, amendment of the NDPS Act in 2001 obviously has not been taken into consideration. Though the judgment of Baldev Singh has been followed by a number of judgments subsequently, it does not necessarily mean that it is now a judgment to be followed only because it is the judgment of the Honorable Supreme Court. So I feel that under Section 24, 19, 27A and other offences connected with commercial quantity, the embargo under Section 37A, 37 of the NDPS Act on ground of bail could be brought into play. But where it is in connection with small quantities, the embargo under Section 37 of the NDPS Act should not be brought into play, which terms reasonable because of the amendment of 2001. So this is an anomaly which is now we are going to face in trials and in bail proceedings and at the time of arrest of people arrested in small quantities, because we have a judgment of the Bombay High Court which says that merely because the person is arrested in small quantities, he is not entitled to bail as a matter of right. Apart from all this, all over the world, a large number of narcotic substances which are consumed day in and day out, particularly in law campuses and others, are being liberalized. Consumption of drugs, particularly in Denmark and some Western countries, including the US and UK, is rampant, and therefore it has been legalized. Consumption is legalized, but trafficking is not legalized. Therefore, the Indian government and the parliament should take note of what is happening all over the world, because if it is not legalized in India, it's not going to come to an end. Only if you put curbs on a society will the rise in crime be rampant. Whereas if you legalize it, like in the case of betting all over the world is legalized except in India. Similarly, if consumption in small quantities, possession in small quantities, for the sake of personal consumption by addicts is found, it should be legalized. So it may not meet the ends of morality in India, because any kind of substance which is intoxicant is termed as an immoral act. So therefore the stigma that is being attached with consumption of drugs, consumption of alcohol or narcotic substances should, be formally accepted in our country, because it is rampant. It is not to be accepted because it is rampant, but all over the world it is being accepted. If we are following all other norms all over the world, why not on the drug-related offences? Therefore, these are some of the suggestions that I have to make, and the bail provisions have to be further reformed, that in such a manner that if an offence under the Indian Penal Code, which is punishable with 10 years, bail normally is granted for filing of a charge sheet, whereas in a case of narcotic substances, only because it is narcotic substances, bail is not granted if he is punishable with 10 years. Therefore, these are some of the suggestions that I had to make. I hope you will take into consideration all these and make your recommendations. Thank you, madam.
Thank you very much, sir, for your valuable presence and valuable input. Despite your busy schedule, that shows your commitment to the cause of justice and your affection.
And to academicians like you.
Thank you, sir. Thank you.
We only use what you teach us. In fact, all of us are, grateful because of teachers like you who have nurtured us.
Thank you, sir. Thank you. It's a great honor to have you with us, and be with us whenever time permits. You're welcome to interact with the students at your own.
I'll see you in the college soon.
Yeah, sure.
Whenever it is open.
Yeah, your goodwill is a great protection for us. Thank you, sir. So as Sir is taking leave of us due to his commitment, I request the other panelists to enrich the discussion further with their experience. Madam Shalini, would you like to comment, please?
I would just like to say that this offense should be have a different treatment, and Dr. Harish Shetty is the best person, at least as regards the amateurs, those who are using it for personal consumption and not for the trafficking. Then they should have a different treatment, and that is for Dr. Harish Shetty to suggest.
Okay, thank you, ma'am. The criminality versus the treatment. So, Dr. Shetty, as a therapist and as a psychiatrist, you must be dealing with this day in and day out with thousands of cases. Doctor, would you like to come in and give your views, please?
Absolutely. I think the first thing is it all started with a single convention long ago. But as of now, NDPS is harsh on users, but very mild on the drug dons. So many agencies, and they are not able to get their hands around big peddlers, the kings. Iqbal Mirchi also could not be held back, and he died a natural death in UK. Rahul Kapoor is also, we don't know where he is. The most important thing, ma'am, the availability, the availability of the drug is so big. I mean, the availability of the drug is so big. In fact, there are two big philosophies: supply reduction and demand reduction. So supply reduction is bringing down the availability there, and this is where we have failed very badly. Now, as far as naming somebody in the media, absolutely wrong. You need to make a clear difference between the users and the drug dons, and that is something which is very important. So stigmatization, those who have used, is not right at all. They need to be treated, they need to be supported. Age of intake of drugs has gone down. The age is 14, 13 and 14. Now there's a big debate on decriminalizing cannabis or legalizing cannabis. There are two words: decriminalizing for use or for medicinal purpose. There are many different streams of thought which is happening, but it is easy to get a drug, much easier to get a drug than to get remdesivir in COVID-19. The law is also very tough. The lawyers are also very expensive, and the fines are also very big. Three things which are very important, ma'am, is humanizing the care of those who are using. And there is no center across the country which is run by the government for teenagers. They're all dumped into government centers for a week, and you get a fitness certificate, and you know that there's at least NDPS Act allows you to be treated. What is very important in NDPS Act is NDPS Act should be made aware to the entire country. The police should be very clear about not releasing names of people. Front page, 24 people have been arrested and they have been found positive for cannabis. So these are the things which are very important, ma'am, and it is big. Drug addiction in India is big. It all started with the golden crescent, the golden triangle, when brown sugar came all over the country. But now cannabis and chemical drugs, MD, meth, etc., which are made in small labs. The contraband which is seized, the seizures have gone down, and the noise is very big. I see three interventions. One is decriminalization of those who use. They can be seen in a different light, but a lot of pressure on so many agencies which are supposed to really apprehend the dons and see that their cases are fast tracked and they are convicted if the amount which is there is big. Three is that a lot of the court should also encourage or should pass orders. I mean, it's too big for this seminar, that we need de-addiction centers for teenagers across the country, which is run by the government. And three, supply reduction has to go down. The demand reduction part is what we do in our work. I work with the National Addiction Research Center. I work with Sevada and De-Addiction Center for 12 to 15 years. And now the picture is completely different. Crime and addiction is also now, it's an overlapping issue, yes, which should also be actually dealt with. Let us not punish the users. Let us not make them bigger than what they are. Let's apprehend the dons and the dealers by effective policing and seeing that the act is used effectively against them. There's also a death sentence in NDPS. I don't think it should be withdrawn at all. History shows that we have been lax on the law as well as on convictions.
Doctor, my question to you is, do you think alcohol is also qualifying to be under that law, and why have we kept alcohol outside of it? And why do we demonize drug, and why do we not demonize alcohol?
Absolutely. I would say, ma'am, that the report of the Ministry of Social Justice and Empowerment has come out, which shows the epidemiological data across the country. It shows that the average age of intake alcohol has actually gone down. Average age of intake of alcohol has gone down, and number of problem drinkers and alcoholics have also. Absolutely, alcohol should be included in NDPS Act. And the last step to be included in NDPS Act was MD by the petition by Dr. Yusuf Merchant in the High Court. Madam Shalini would remember that. MD was the last step to include. Alcohol should be criminalized.
Yes.
And not be criminalized. It's all about the context, ma'am. Everybody is saying, let's allow controlled use of cannabis. Abroad, they have allowed controlled use of cannabis, and the crime has gone down. But if you see the reports of Holland, if you see the reports of USA, controlled use has not brought down the amount of cannabis sold by the mafia. It has not brought down the amount of cannabis which has been sold by the mafia. I would say every substance which is harmful should be criminalized, and probably the law should evolve where it can have a license to obtain what is there. Alcohol should be safe, legal, and rare. Opium is available. You can apply for a license for opium. You can apply for a license for opium. There has to be a national debate on the substances and what the law should be. But the voice of the debate is extremely big on decriminalization. But the point is, it is important to understand that this has caused a lot of harm, physical, psychological, and economic across the country. And the number of people coming to mental professionals have increased because it is easily available. And also the angst of the society and availability is a very bad cocktail. You should have a separate seminar only on the NDPS Act.
Thank you, sir. Thank you.
Thank you.
I would request Arvind Tiwari, sir, to quickly respond on this issue, if you can.
Most of the things have been said by Dr. Sethi. What I would like to say, the data, if you will see in crime in India, 2019, the conviction rate under NDPS Act, it shows 76.8%. That means conviction rate is very high. So the question is whether the drug traffickers, those who are amassing huge money, are they being punished by the law? No. The question is, answer is very clear. So therefore, the implementation of the NDPS Act by the central agencies or anti-narcotic cell here in the state governments, they are catching the petty offenders and drug peddlers and consumers. So therefore, there is a need to this should be addressed in a very serious manner. And because of this corruption, if you will see the N. Bohra Committee report in 1993, which has very clearly said there is an unholy nexus between the mafia, the bureaucrats, the politicians, and therefore this kind of when we are discussing NDPS Act, then I also feel so that we must retain the capital punishment, death sentence for the traffickers, but that let the traffickers should be caught by the system and should be punished by the system.
Thank you, sir. Quickly, Professor Raina, would you like to come in and respond quickly? And then our police officer, Banu Pratap Barge, sir. Barge, sir, are you there? Professor Raina, are you with us?
Ma'am, Barge, sir, is not here.
Professor Raina?
No, ma'am, Professor Raina.
Would anyone else like to comment? We have time for one comment, because we have captured all the angles. So over to Shirish Kulkarni. Would you like to comment and then end this process?
Okay, ma'am.
We'll put it for voting now.
Polling, yes, ma'am.
Yeah. So we have covered, So we are questioning the death penalty and all these legitimacy. So we have covered this theme successfully. We have put it for polling by the audience as well. Thank you, esteemed panelists. Now we will move to the last theme of the day, which was the penultimate theme, but becomes the last theme, which is more like a means as well as approach to investigation and changing the whole face of Evidence Act. So over to the moderator, over to the compere.
Thank you, ma'am. Thank you, ma'am. And I also thank all the panelists and moderators for their comprehensive and insightful deliberations from a legal, ethical, psychological, as well as sociological points of view. It's very appreciated. We'll move on now to the panel on cyber and forensics, wherein we are going to invite Dr. Shashikala Gautam ma'am as the moderator, and to join her, we have Dr. Atmaram Shelke once more, who will be moderating this session. So I invite the moderators to begin the discussion of this.
Thank you, Professor Lasya. I invite Professor Atmaram Shelke, my co-moderator, to present the survey data and then we put it up for discussion quickly to summarize. Yeah, over to you.
Okay, thank you, ma'am. Good evening to all. So this is last theme, and it is a combination of cyber law and some question or some recommendation with respect to IPC and CRPC also. So I'll read it out and then discussion will start. So one of the recommendation was about the increase in the lab of forensic and computer science. That was also covered in the prosecutor and police coordination. So right now, according to the some stakeholders, including police, they are getting a report of forensic lab and computer forensic after 1.5 years. And before that, they are not able to utilize this report as part of the investigation. So they are not getting help of the technology in the investigation or while submitting the charge sheet. And then another suggestion was there is need to increase the advanced scientific tool to extract the information. And principle, no touch to body shall be followed. So without touching body, without using third degree or any degree on the accused or with respect to victim, we have to utilize scientific method like brain mapping, narcoanalysis, etc. to extract the information. And then for that purpose, we have Selvi case and section 45 to take the Indian Evidence Act to receive or to take the opinion of the expert. Next suggestion on this part was there is need to have special chapter on digital evidences, because in digital evidences there is need to have more categories. Few are more reliable, few are less reliable. So accordingly, the emphasis can be given and subcategory can be made. And next suggestion on this forensic was the forensic and computer experts should be part of investigating team. Whenever it is sensitive offense, our team is formed for doing investigation in socio-economical offense or sometime in the offense of rape, etc. Also, a team is formed when there is a burden on the prosecutor. And followed by that, there was another suggestion about need to have manual on collection, preservation, and securing the digital evidences. Because while collecting digital evidences and while securing digital evidences, there are few mistakes done by the investigating officer. And this has been widely supported by the stakeholder. And some data or literature is also available on this point. Next recommendation is need to have sentencing commission and need to adopt sentencing grid, which is there in USA. In USA, there is sentencing commission. After proving the conviction, the matter is handed over to the sentencing commission. And this sentencing commission is not responsible to the judiciary or executive. They are created by the statute and they are directly responsible to the parliament. And the judge in case of greed have only 10% of discretion to change or to variation for the variation in the sentencing. So it has been managed with help of greed, whereas in India, there is no adequate sentencing guidelines. More particularly in case of death sentence, the massive burden to provide death sentence is provided to single judge. Definitely it has been approved or there is process to approve it by the High Court. But in High Court also normally it is division bench who is approving. And therefore for this purpose, for this type of heavy burden on the accused, the collective wisdom which is utilized in USA, that is group of person deliberating and deciding what shall be sentenced, particularly in death case is not happening in India. And therefore, the suggestion was for the offense punishable by death, whether standardization of criteria is required. We have raised up rare criteria, and from Bachchan Singh's to recent cases like Sangeet versus Haryana, it has been discussed from time to time. But in USA, there is more standardization as compared to India. And there is sub-classification of the offense punishable by the death. Like they will mention that murder plus outraging of the modesty, whether it need to be considered for the death penalty and how it need to be considered. So in India, there is no sub-classification, and that call shall be taken by the legislative authority. The last point in the previous slide was about the deciding the fine. For deciding fine, there is no criteria. So fine shall be person specific, and then only there will be deterrent effect. Now fine is offense specific. For example, in trafficking and even offenses with respect to traffic, 5,000, 6,000 fine is imposed irrespective of economical capacity of the person. So rich people will not have any deterrent effect with respect to fine to be imposed. And similar thing is happening in the court of law also. And therefore, the suggestion with respect to that is fine shall be connected with the income of the person. So if there is a software, only two things need to be put up. One, section number, and then the PAN number of the person. So if it is 0.5 fine from the, as calculated with respect to income of the accused person, automatically that software will calculate the fine based on the income, and it will draw what is the 0.5 and fine will be imposed. So there will be no human interference in that. Next suggestion is about Indian Penal Code, that is need to consider mental health as part of section 84. That is offense with respect to or liability with respect to lunatic person or unsound mind person. So right now mental health, and there are various levels of mental health which are not considered. So whether it need to be considered, that was the issue, and many people have stated it need to be considered. And followed by there was next recommendation about mental age shall be considered while deciding the liability. So we have 84 wherein below 7 is completely exempted, between 7 and 12 partially exempted. So that was the issue, whether mental health shall be considered rather than actual age of the person under the general exception of the Indian Penal Code. And last recommendation in this part was about the need to implement plea bargaining effectively. I think previous experts have also spoken about it, and it has been supported by 86% of the stakeholder. And we have right now section 265A2L of Criminal Procedure Code. And according to expert, there is lack of effective implementation of provision of plea bargaining. Thank you. Over to moderator.
Thank you, Atmaram. Now I request the panelists to come in and give their views, particularly Harold De Costa. Are you there? Could you give us some insights on this?
Yeah, madam, I'm there.
Yeah, please. It will be great to listen to you because you have been.
Yeah,
Anything else happened? Have you been kidnapped?
So, what is the role of cyber forensic? And then
am I audible?
Yes, yes, Harold. Yeah.
Yeah, in fact, the role of cyber forensics in today's crime is of a great magnitude. In fact, when you talk of any evidence today, almost about 70% of the cases today have got somewhere the digital evidence in place. But when you talk about the cyber forensics and specifically about the labs, we have got a very big shortage of labs in our country. In fact, there are only 4 states where these 4 states labs are known as the electronic examiner labs. And that doesn't mean that the other states, they don't have the forensic lab in place, the cyber forensic lab in place. But then there's a huge shortage, and most of these so-called cyber labs, they've got the people working on contract basis. I think that's something has to be taken care of. We cannot leave the extraction of the data, which comes from the digital device, to be given up to the people who are working on the contract basis. The other most important issue when you talk about the digital evidence, the data which is extracted from the system, is basically about the Section 65B. In fact, just a few days before, I was just on a webinar, addressing the law enforcement agency. And what shocked me to hear that a constable signs on a Section 65B certificate when he takes the extracts the data from the accused device. Well, that's not a right practice. Sorry. Well, that's not a right practice, because when you have the data to be extracted from the accused device, there are forensic labs. But then these forensic labs takes a lot of time, 2 years, 3 years, for them to have the report to be sent to the court. So the law enforcement takes a shortcut, and the shortcut is that they have today we have some constables, we have some the head constables today who are little IT savvy, and these then they are then been told to extract the evidence or the data from the accused digital device and then have the Section 65B certificate to be produced. I think this has to be taken on record, that we have specific cyber forensic lab, which of course are in shortage today. There has to be an exponential increase in this cyber forensic lab, wherein the accused digital device has to be sent to the forensic lab for this forensic lab then to extract and then present the report to the court and to the investigating officer. I think that's one part of the story. The second part of the story, as to when we talk about the cyber forensic, well, today the field has moved to such an extent that digital evidence can deceive us. The time has come that you can have a WhatsApp account created with a virtual SIM number. In fact, you don't require a SIM to create a WhatsApp account. Well, you want to have a Facebook account to be created, for that matter, any social account for that matter, you don't require any mobile number or a SIM number. In fact, there are so many techniques which are freely available on the internet where a criminal can use a so-called mobile number, which is just available for 10 minutes. And after 10 minutes, the whole particular information regarding that mobile number gets to be completely destroyed. Well, there are instances wherein you have email IDs, which could be bought only for 5 minutes or 10 minutes. A social account could be created. And once the account is created, these email IDs are self-disposable. I think today the law enforcement agency have got to look across from a very rational point of view, and that is, how do they investigate this modern type of cyber crimes, and for which you require the help of the cyber forensics, the cybercrime investigator coming from an industry to work with the law enforcement and also to work in tandem, supporting the judicial system in ensuring that the extraction of the data, the seizure of the data, the preservation has been done, which is morally correct, technically viable, and which could be admissible and appreciated by the court. Well, that's what my say is all about.
Thank you, Herald. You have been one of our prime trainers and an expert that we consult all the time. So true to your expertise, we are very enriched with your comments. I would now request from our team of panelists, maybe Justice Shalini ma'am, would you like to intervene? Or shall I proceed to Arvind Tiwari, sir? Would you like to talk?
Yeah, a few points I would like to submit. Like I will say about the forensic evidences, now which are generally used by the police regarding crime against women, crime against children, crime against marginalized section of the society, because as we know that in more than 80% of the cases, the witness turns hostile. So now the scientific aid to crime and particularly forensic evidence are very, very important. But there are few problems. Problem number one is that each police station because of we were discussing that separation of crime investigation and separation of law and order, two divisions at the police station level, as had been said by the Supreme Court in Prakash Singh's judgment. So because of this, because IOs are hard pressed and many times they do not use these techniques, either they don't use or these expertise is not available at the local level. So this is one problem. Second problem, there is, despite having knowledge of forensic science, and few universities are offering the courses in law courses are also in bit and pieces, they are having this course. But there is a need that the prosecutors, the magistrate and judges shall also be oriented regarding the appreciation of these evidences in such a manner that they must ask that whether the scientific tools were used or not. Third thing is, as has been said regarding cyber forensic, even in the forensic science laboratories, the human resources, the scientists are recruited on the basis of the temporary positions or on contract basis. I think the government should give the priority that they should fill up these vacancies and they should have the permanent position to the people so that things can be done. Victim, I think victims should also be given a right to know whether any scientific tool was used while investigating the crime, because many times there are some judgments where police has even used the scientific tool, but has not included the report of forensic science lab if that was not according to their research. So therefore, there is a need to have develop some system where the accountability of the police and other criminal justice functionaries should be made, that they must use the forensic tools for crime investigation and reaching out to the decision, and this should be made part of the fair investigation and fair crime process. Thank you.
Thank you, sir. We have our in-house forensic expert, Dr. Vinaya Lambert, who I think also is trained in the university where you were trained, as well as Dr. Bajpai was trained. She says that facts show that most of the forensic laboratories take no notice of or disregard forensic science, qualified forensic science graduates and postgraduates in recruitment. It affects the flawless identification and collection of physical evidences and outlook, the perception, analysis. So it impacts and delays the further processing. I mean, that automatically affects the conviction or the efficacy of the criminal justice system. Totally agreed, Dr. Lambert. Thank you very much for that valuable comment. I have two people here who could quickly come in and enrich our discussion, and then we can wind up. One is we have Dr. Harish Shetty. Would you like to respond? Because the mental health dimension was brought in by Atmaram Shelke. Dr. Shetty, you will have to unmute, I think. Who has muted Dr. Shetty's mic?
Yes, ma'am.
Sir, we can hear you now, please.
Yes, ma'am. I think.
Okay, ma'am. Issues we have.
Sir, Dr. Shetty, sir.
Yes.
Any comment?
I think its connection is missing a little bit.
Okay, then we also.
Its connection is missing, ma'am.
Okay. In the meanwhile, Advocate Sampath Bulusu, would you like to come in? Advocate Sampath Bulusu? Some connection problem. Since yeah, Dr. Shetty, please.
Me and my friends run an NGO known as Responsible Netism. Sonali Patankar, Umesh Joshi, and me. It is very difficult to get a case resolved because the number of cases are so many. So forget the law. The number of cases are so many with respect to cyber hygiene and cyber issues. Though there are agencies and labs, as Harold said, the issue is so massive that very few people get prosecuted and convicted. They have added simple things in the IT Act
which is, so example, if I send an SMS to somebody which has some, so we need to make it a little more contextual in the sense in 2020, what is the role of communication, what are the words used, etc., etc. And I think it has to be contextualized with the debate across the country. The law is made in the parliament, but debates which should happen for the law to become more dynamic and more contextual has not happened. Number two is that all the changes which are happening on the cyberspace is so fast. In fact, the Prime Minister's website got hacked yesterday. So we actually need to look at not hanging every small culprit. Say, for example, somebody said something, and the language may be so different than what the person likes, but such languages are used by a lot of young boys and girls. So we need to look at that in making it a little more liberal, though it should be very harsh on crimes which are very big.
Thank you. Thank you. That gives a very balanced perspective. And I don't think Advocate Sampath Bulisu is here. We have to now ask our co-moderator to wind up as he puts it up for polling. Mr. Agarwal or Mr. Chavan, would you like to speak anything in this regard? Maybe the last comment from you as people representing the National Legal Services Authority. Otherwise, we will end the proceeding here for this panel. Thank you, Dr. Atmaram. And I hand it over to our moderator, our compeer, Professor Lasya, please. Thank you, panelists. All of you made a very valuable contribution and enriched the discussion. Thank you.
Thank you. Thank you, everybody.
Thank you, ma'am. We can have the results of the poll displayed. In the meantime, I would like to thank all the panelists, esteemed panelists and experts very much, and the moderators who have wonderfully moderated each of the panel sessions today. And we have been able to glean today from the cumulative expertise of decades of experience in this public consultation. And so in order to summarize all the deliberations that have taken place and to deliver the concluding remarks, I would like to invite Dr. Shashikala Gopal again.
So dear all, you must have been bored of me. I have been talking and letting others talk as if I'm regulating everybody's speech here. But I must tell you that the background work here has been of more than almost 3 months plus a couple of weeks. So our team has identified the issues based on their research background, especially Dr. Atmaram Shelke. And our criminal law experts, including our some younger professors, and our PhD researcher, Ms. Aditi Mane, who due to her hard work today, she was so exhausted, who could not be here, but a wonderful presenter and researcher, among others. And Ashish Deshpande with his PhD in prosecution. So we have really gained here, not only by the brand and excellence and quality of Symbiosis, but mainly from the experience and expertise of our faculty, who are emerging researchers. My own background in Law Commission has enriched this whole idea, but before the Law Commission, I'm a science graduate and I always believe in applying what I learn and in a very empirical manner. So we also saw the flaw that most of the time, even in the Law Commission, we saw that empirical research was something that was never done. Community-based or stakeholder-based, participant-based dimensions coming into the body of law. So we thought this is our golden opportunity, whereas other law schools are engaging in the technical research, which is again primary data of judicial pronouncements and legislative provisions, comparative law, and scholarly writings. We thought we will also learn from the people who speak a different language in the community, and then experts and synthesize. So part of the synthesis was done behind the curtains. Part of the open synthesis was done today in terms of polling as well as panelists further enriching the discussion. I think what we brought was 60%. It turned into 100% with our esteemed panelists. From here on, what do? Within a week, we will consolidate this And point-wise, we will be making paragraphs and thematic paragraphs of these 7 areas. And the justification will come from the initial quick presentation I gave. And then we will write our recommendations. This format which we have shown, same format, but in a very different manner. In a systematic manner, it will go to the ministry and we will circulate the copies to. We'll acknowledge the effort of each and every one of you. The recording will also go to the ministry. So I'm very honored to make the closing remark and to keep the promise, and also to be enriched by your sacrifice of number of hours and number of ideas and the openness and your commitment to this mission of improving the justice system and criminal justice system in particular. Criminal justice system is having very close bearing with the quality of life, because security is something around which all other constitutional and human rights guarantees could be realized. So criminal justice system is closely bound up with that. Secondly, it's criminal justice system being closely bound up with that, which could have some endangering qualities as far as human, basic human dignity and freedom are concerned. So it's a tightrope walk. It's like walking on sword's edge. So the kind of dharma exercise that we do in criminal justice system is much more tighter kind of exercise. So I hope that we have touched that mission of justice, and also the aspirations of the Home Minister himself, and the special emphasis that was laid by his ministry, and unveiling areas which other law schools or other team of experts did not unveil. We had cyber experts, we had psychiatrists, we had NALSA people. I don't think they were engaged in the earlier different exercises. So I thank each and every one of you. I learned a lot. Today's class has been, I mean, it's a 5-hour deliberation. None of you showed any tiredness or any boredom. You were so willing to give the resource. That shows your spirit, and that also demonstrates your richness in terms of your resources. Some of the people I should note here, Dr. Arvind Tiwari especially, or someone like Harold or Dr. Shetty throughout in every session, and our own alumna and GM legal from Shell Hazira, who had been a very young legal prodigy, Sampath Bulusu, and our another distinguished alumna who is working closely with the government, Hitesh Jain, and his dad, Mr. S.K. Jain, and most of all are reputed lawyers. I mean, if I don't mention a few, that doesn't mean you are not important, but I'm also taking these names because we had, we never thought that we will have an occasion to engage them, be though online, but the output is the same. So we have had Ujjwal Nikam sir blessing us, and we have also had Satish Manishinde sir. So it brings more of authenticity to the effort, because they are in currency and they are working cases. Some of you are writing a lot, publishing a lot, investigating, having your own research projects. And the crowning glory is our team who are working. Even now our work is going on in the Eravada prison. Our work is going on in training the CID officers, the prison officials, different police personnel. So all that has come into a kind of perfect integration and whole in today's exercise. So I'm sure the audience would have been enriched, the panelists would have been enriched, and we would still look forward to any other comment or reflection which will come into your mind. Please don't hesitate, just mail us. You have our IDs, you have our resource persons and research team which is engaged. I especially thank Dr. Shelke and his team, and Dr. Rupal, my Deputy Director, Dr. Bindu, another Deputy Director, Professor Kshitij, and our admin team, ICT team, for making this 3-month plus exercise coming to a kind of fulfillment that I had visualized in the beginning, and our compere also made it. So thank you one and all, and please look forward to our recording linkage when it comes on YouTube, and our consolidated recommendations copy when we are sending it to the ministry. It should not be later than another week. So once again, I salute you all for your resources and your contribution.
Thank you, ma'am, for summarizing all the efforts that have been taken by the army of people who have been behind this project. I would now like to invite to deliver the formal vote of thanks, Dr. Bindu Ranul, the Deputy Director of Symbiosis Law School, Pune.
Thank you very much, Professor Lasya. as we come to the end of the wonderful and very, very fruitful discussion on the transformation of criminal justice system in India and the various issues. It's my privilege to thank all those who have contributed to the success of this virtual discussion and public consultation. I thank all our esteemed panelists for sparing time from their very, very busy schedule on a weekday, contributing to the discussion and sharing your wisdom. I'm sure your inputs here will surely help the team to further refine their drafts. I take this opportunity to thank our top management, Dr. S.B. Mujumdar, Chancellor Symbiosis International University, Dr. Vidya Yeruvdekar, Pro-Chancellor, Dr. Rajni Gupte, who's the Vice Chancellor, for all the support and encouragement they give to the law school. Dr. Shashikala Gurpur, Director, Symbiosis Law School, Pune, has been the main pillar in organizing and managing the details of this discussion. She's a person who goes into the details to ensure that whatever is organized at the law school is par excellence and contributes to knowledge generation. Thank you, ma'am, for guiding the entire team and also moderating all the sessions today. This discussion has been the result of a lot of hard work by a team that was led by Dr. Gurpur, and I take the opportunity to place on record the contribution of the entire team, namely Dr. Atmaram Shelke, Ms. Aditi Mane, who is the Junior Research Fellow, Dr. Ashish Deshpande, Ms. Chaitrali Deshmukh, Professor Shirish Kulkarni, Ms. Apurva Singh, she's the Junior Research Fellow, Ms. Aishwarya Mane, again the Junior Research Fellow, and also the support and assistance that were rendered by Professor Dr. Rupal Raut Desai, Professor Virendra Singh Thakur, Professor Priyanka Mujumdar, Professor Shimanti Chowdhury, Advocate Sangramjit Chavan, and the IT team, which was led by Amit Jatale and Balesh Jolvekar and all the others. I also thank all the participants who have been part of this virtual discussion. Your presence definitely increases our confidence to do even better. Thank you once again for being here and being part of this discussion. Thank you.
Thank you all. I hope we have taken some group photograph, and I must also put on record a wonderful person who has been our mentor and our colleague and our inspiration, Dr. Shalini Pansalkar Joshi, who from the beginning till then was on all the panels along with Sampath Bolusu and Dr. Shetty. So in particular, and Latika Salgaonkar, our visiting faculty.
Thank you, ma'am. It was really interesting and enriching exercise. Thank you so much.
I request all the panelists who are available now and the participants of the discussion to kindly switch on your videos so that we can get a group photo.
And our research team of Chaitrali, the Atmaram. Please put on your videos. Dr. Shalini ma'am, could we have your video on? Dr. Shetty, with all your PPE. Harold, I'm sure most of you are here. Yeah. Latika ma'am. Are we done or we need more shots? Thank you. Thank you very much. Are we done?
Thank you. Yes, ma'am.
Yeah, thank you.
Thank you. All the participants may feel free to leave the Zoom link now. Thank you very much.
Thank you very much.
Thank you all.
Thank you, ma'am.
Thank you, panelists. Good luck. And thank you, team. Chavan sir, you have really enriched us. And also Agarwal sir, both of you gave the authenticity coming from the government. Thank you.
Thank you. Thank you.
Rich contribution. Thank you.